All right, it's now just a little after 10. I'm going to call the meeting of the House Judiciary Committee to order, and I'll first recognize Representative Page and ask him to lead us in the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, I'm going to now open the hearing on Senate Bill 141 FN, and I will first recognize Joshua Schauer, substituting for Senator Gannon as the prime sponsor of the bill.
Good morning, Mr. Chairman and members of the committee. For the record, my name is Joshua Schauer. I'm the legislative aide for Senator Gannon. He was in committee, so he asked me to introduce it. So thank you for the opportunity to introduce Senate Bill 141, which would ensure innocent people have an opportunity to file a motion for a new trial and be heard. This bill is about liberty, fairness, and due process. Filing a motion for a new trial is a critical mechanism to reveal wrongful convictions. However, New Hampshire has a 3-year hard and fast deadline. Under current law, someone can file a motion for a new trial on any grounds if it's within the 3 years. But after 3 years, a wrongfully convicted person is denied an opportunity to file a motion even if they have new evidence of their innocence. This arbitrary deadline is restrictive, especially when you take into account that on average, it takes 11 years to be able to identify and correct a wrongful conviction. This bill creates a narrow exception to the 3-year deadline and would allow an individual to file a petition even if they have newly discovered evidence, new forensic testing, or new scientific understanding. To be clear, Senate Bill 141 is only changing the time frame a person has to file. It would allow a wrongfully convicted person to file a petition which the court can still deny if the petition does not meet the legal standard. This bill is about improving our system so we can identify and correct wrongful convictions. According to the National Registry of Exonerations, there have been 3,659 exonerations nationwide. Yet in New Hampshire, there have only been 3, which isn't a lack for innocent people being wrongfully convicted, but because of outdated barriers in the law blocking them from proving their innocence. This bill will help those people find a pathway to freedom. Thank you. And I know if you have any questions, there's some people behind me that can probably answer it better than me.
All right. Thank you very much.
Yep.
Right. So next, I'm going to call on Cynthia Masso and Winnie Yee. And I should note, just for the record, I have spent some time over the last couple of days drafting a proposed amendment to this bill, which I've given to all members of the committee, and I've given it to people in the audience. I haven't submitted that as a formal amendment yet. We're not going to exec this bill until next week. I would love to get, obviously, comments from members of the committee, but also from anyone in the audience who has views on this. And I think you'll see, as you look at this, basically what I did, being mindful of the veto of House Bill 5 or Senate Bill 507 last year, and the comments of the governor at that time, which I thought were well taken. I've used the DNA statute as kind of a format for this proposed amendment, but obviously made changes to because this would cover a broader range of requests for a new trial than just DNA. So I welcome your comments. Ms. Masso and Ms. Yee.
Good morning. Thank you, Chair Lynn, and thank you to the committee for your attention on this matter. My name is Winnie Yee. I'm with the Innocence Project, and today, alongside the New England Innocence Project, we want to express support for Senate Bill 141. This is a bill that would improve the post-conviction mechanism in New Hampshire. Over the years, the increasing availability of DNA testing, as well as advances in forensic science, have enabled the wrongfully convicted to prove their innocence. And in New Hampshire, there are only two pathways that someone who is wrongfully convicted can prove their innocence. The first is through the habeas corpus petition. This is a petition that is only for constitutional claims, so the individual must show that their constitutional rights were violated, something like a Brady violation, or maybe ineffectual assistance of counsel.
Can I just ask you a question? You know, I had until yesterday, because I hadn't looked at the habeas corpus statute recently, I thought that was right. But if you look at the text of our habeas corpus statute, it doesn't say that you can only get habeas relief for constitutional violations. So I'm just, I guess I'm curious about whether you, on what basis you say it's only for constitutional violations.
So I think the practical reality is it's not in the statute. That's not where it's coming from. It's from the interpretation of the statute. And the issue for us is less that it's less that it only covers constitutional basis and unclear whether innocence is covered. So the practical reality is in a lot of these cases where we're claiming factual innocence, it has been unresolved in case law that interprets habeas corpus proceedings, whether innocence would be considered a sufficient grounds. I don't think the statute, and if I have ever said that, that would be a misrepresentation that the statute says that. It's from the case interpretations of habeas corpus law that would suggest that there is sort of these buckets, and generally it is a constitutional violation, and innocence is definitely not a resolved issue that innocence would be grounds for a habeas corpus. So it is by no means an option that is guaranteed to us.
Okay. All right. I'm sorry. I didn't mean to interrupt. Go ahead, please.
No, that's okay. I just wanted to lay out for the committee just what the general sort of pathways are. So there's the habeas petition, and then what most folks rely on would be RSA 526, the motion for a new trial. As was mentioned, this statute does have a 3-year deadline. So before that 3 years, an individual can file a petition for a new trial for any grounds, and the court would review that accordingly. But after that 3 years, an individual is denied the ability to even file a petition. And we know that it can take years for newly discovered evidence to appear, for science to evolve. Our science and technology and understanding of science is always evolving. So a 3-year deadline is really restrictive and does mean that there are innocent individuals who are outright denied the opportunity to file for a petition after that time frame. To address this, Senate Bill 141 would create a narrow exception to that 3-year statute of limitations. And so a person can overcome that 3-year bar if there's newly discovered evidence, new forensic testing, or new scientific understanding in their case. This is especially important because there are so many different changes in science. For example, experts once believed that they could tell the difference between a fire that was set accidentally versus a fire that was set intentionally. And arson science was used to secure many earlier convictions. But in 1992, the National Fire Protection Association reported that many of the physical signs that they thought could be used to indicate that a fire was intentionally set were actually invalid, and that could actually also occur in an accidental fire. This was later corroborated by a 2009 report from the National Academy of Science, finding that this and other forensic disciplines were unreliable and invalid. And so because of these invalid sciences, we do need to make an exception to the 3-year bar, and that's what Senate Bill 141 does. I know that some individuals are concerned about a flood of frivolous litigation. In the history of working on these reforms, that has never been the case. This is just creating a very narrow exception to the 3-year bar. It is just cracking the door open for the innocents to file a petition to be heard. The judge would still review the petition. It could still be dismissed if it is not meritorious. But this would just crack the door open for folks to have that opportunity to file a petition given this 3-year hard and fast deadline. I'm going to turn it over to Cynthia to also provide some comments.
So I would draw everybody's attention. We've handed out a fact sheet that has as its title New Hampshire Senate Bill 141, and then the back of that has a chart of the entire statutory scheme of RSA 526. The reason we've handed this out is that it shows sort of the very narrow exception that we're trying to draw, and it shows you in 526.1 the standard that the court could still use to deny a motion for a new trial. So to be extremely clear about this, we are not trying to create a new cause of action here. We are trying to make a very narrow exception for when you can plead, not for when you would be getting a new trial. The new trial motion standard remains the same. In other words, the court can still deny on the basis of saying this forensic science was available at that time and you had your opportunity and you can't revisit it now. This forensic science wouldn't make a difference at the trial. So even though it's different, it really wouldn't have changed the outcome because there's still overwhelming evidence of guilt. This standard still is in place. We're not trying to create a new pathway. We're just trying to allow people to appeal in court. Currently, there are examples that I can talk about a little bit where, for example, we would not be able to access the court at all. So, for example, in sort of this arson setting, should we have a case where in 1988 there's a fire set and somebody dies and someone's charged with this arson and the murder that accompanies that? If there's new science that shed light on this arson, that's not evidence that the state withheld. That's not a mistake that was made by the council. That's not something that would necessarily fall within a HABE because it's not something that falls under ineffective or falls under what we call those Brady claims, which is when the state withholds evidence. So this is something that wouldn't be able to be accessed by a HABE. And because it is now 2025, we're outside of that 3-year statute of limitations. We cannot access the court now on this arson science, even though we know the arson science has changed and would now suggest that this fire was either accidentally set or set incidental to something else that had nothing to do with the person that was charged and convicted. So there's examples like that that would show you that I cannot access the court on behalf of clients who are sitting in prison for things that they haven't done. The other chart that we've handed out is a two-sided chart. There's a title in black on one side and then a title in blue on the other. This chart we're using to show you exactly how the standard works now. That's the side that's titled in black. So that's the current version of the statute. And then on the back, the blue and the highlighted blue section is the only change we're trying to make. And as you can see there, the bottom two boxes on both sides are identical in that the court can still deny the motion for a new trial on the grounds that it's not through accident, mistake, or misfortune justice has not been done. So we're really not trying to make any adjustments here. The amendment that Representative Lynn has shared is extremely comprehensive, and I appreciate all the work that you've done on this. And I would love to do a more comprehensive forensic science overhaul because I know that our statute in terms of the DNA statute is even outdated because it doesn't include forensic science beyond DNA. And when we first wrote that DNA statute, I don't think we thought that there was going to be other forensic science changes that were taken into account, and now we know that things have changed. The issue with this statute is this is just not what we're trying to accomplish today. I'm trying to get people in the door now, and this statute is just much more it's more of an overhaul than what we were trying to accomplish. In addition, there's a couple of things in here, and I would love to take a look when we have a little bit more time and take note of this. This is just not what we're trying to accomplish. We're just trying to open the door under a statute that already exists, under a standard that already exists, with a court that's already been hearing these, just for a little longer of a period of time. There's a couple things that I can see right in this amendment that would be significantly different. There's additional hearing levels, so there would be secondary or additional hearings. That's the way it's worked in the DNA statute, which I've been litigating. So there would be additional hearings. There's also pieces about adding counsel here. We're not requesting an addition of counsel or anything like that. There would just be a number of additional pieces here that I think would be, things that concerns that have been raised about our amendment, for example, is that there would be a flood of litigation. Here, when we're allowing folks to just come in and test for the first instance, that's going to encourage people who don't even have a basis to request testing in the first place. So I think there could be some pieces, and I would love to work with you, Rep. Lynn, to make a more comprehensive forensic science testing statute. I would be happy to do that. I think what we're trying to do now is just apples and oranges. We're just not trying to accomplish that here because we're not trying to create a new cause of action. I would love to do that. I just think this is not the place that we're trying to accomplish that today. What I'm trying to do is be able to get folks in the door on these cases where we would still be able to fit under the statute as it stands now. I'm trying to think of. Oh, I'm sorry.
No. I didn't want to. Go ahead, please.
I just wanted to make sure that I made all the address some of these issues. I know Winnie had mentioned that it takes a really long time for these cases to get resolved. It does take on average 11 years for an exoneration to go through, and 3 years is just insufficient for that, which is another reason why this statute is unworkable as it's written now. I think everybody sort of agrees that we want to be able to get in. And I think this, in this spirit, I know that this is where that's aimed. And I really think there's a lot of really workable things here. It's just that for today, what we're trying to do is just be able to crack the door open in a very narrow way for very few folks so that we can get in there and be able to start litigating these cases now.
All right. Questions for these witnesses? Yes, Representative Perez.
Thank you. Thank you for taking my question. So are you proposing an amendment to this bill?
No.
No. Okay. Just wanted to clarify.
Other questions? Yes, Representative Rombo.
Thank you, Mr. Chairman. Thank you for taking my question. I understand the idea of the exception based on a certain level of conviction, new evidence, but the language about incarceration subject to terms of a sentence or subject to collateral consequences of the sentence. Could you just explain to us what collateral consequences of a sentence might be?
Yeah, so there's a number of
Please.
collateral consequences that can be associated with criminal convictions. There's things like gun ownership. So that's one thing, for example, and in a lot of misdemeanor cases, once you have a domestic violence conviction for a simple assault, even you're not allowed to own a gun for the rest of your life. So that's one very specific example. Other things you'd have to add this into employment. You'd have to add this into housing applications. You can be denied certain funding for like federal funds for college scholarships. There are the sex offender registry for certain offenses. Those are things that outlast a sentence, like would outlast even probation or parole in some circumstances, but you would still have those outlasting.
Quick follow-up.
Yes.
So what you're describing is different than the subject to the terms of sentence, meaning probation or parole afterwards. That's
Right.
something that but they're still being monitored versus
Yes.
collateral impact.
Yes.
Okay.
It wouldn't necessarily be monitoring, but you would still be subject to like laws and rules that are collateral because of the conviction.
Right.
Yes.
Okay. Thank you.
Yes.
Other questions for, yes, Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. I reviewed the Senate testimony, and there was discussion about Chapter 526, which is new trials, and whether it's applicable or not. And as I read it, there was question about whether it only applies to civil trials or not. And as I read it, I would think that it does only apply to civil trials because it says 526:3 says costs grant on terms. Costs may be allowed to either party upon such petition, and the new trial may be granted upon such terms as the court may deem just. And when it says costs may be allowed to either party upon such petition, I view that as being civil and not criminal.
So this has been interpreted by the courts already, and it's being used by the criminal courts already as motions for a new trial. It's being used regularly in New Hampshire. I know Replin was a judge and has had experience with that, but that's how it is being used in criminal cases. So that it is applicable in criminal cases.
Okay, may I have a brief follow-up?
Yes, sure.
So you view this also as being a limitation, a 3-year limitation?
I don't think I'm clear on your question.
Doesn't 526 also contain a 3-year limitation? I think it does.
526 has a limitation as it currently stands in 526-4. That's what we're trying to amend.
Okay, all right, okay.
That's
Thank-
the yes. I feel it. Maybe I misled. When we printed this on the back of the fact sheet, the 526. The reason we did that is to show you that the piece that we're trying to amend is 526-4, and that 526(1) still remains in place. I'm not trying to change 526, the entire statutory scheme, just the one provision.
Okay.
Sorry
Thank you.
about that.
Thank you.
Apologize.
Other questions for these witnesses? Seeing none, I guess I just have a couple. The one question that I have is the way the bill is now drafted. It seems, and this is really one of the prime reasons for my proposed amendment, is it doesn't require any, for lack of a better term, any sort of enhanced pleading or preliminary review by the court as is applicable in the DNA statute. And my own view is that something like that is necessary, because I have to respectfully disagree with the idea that, we, particularly for people who are spending a long time in jail and have lots of time on their hands, based on my experience, there are more than a few frivolous cases, and it seems to me that suggests that there should be some initial level of screening before the court has to go further.
I think our concern was when folks were raising concerns about the flood of litigation, we were trying to reduce the number of hearings that the court was going to have to hear in order to keep that level down. But we really don't have a problem with having an additional requirement that the petitioner must plead innocence in these cases. I have no problem with that sort of an amendment here. That would be completely fine with us in order to address some of the concerns that you've raised. I just think that this statute, I think, is going to have the unintended effect of inviting additional. This is a whole new cause of action. So now there's going to be, when we discussed this, there was a discussion about how there would be new trial motions filed under 526, habeas corpus petitions filed simultaneously. Now we're inviting petitions under Section 534, which I think would end up being additional with a two-part hearing, at least a two-part hearing here, and a guarantee of counsel if they get past the first part, which I think involves additional hearings and additional fiscal issues. So I have no problem with
let me ask you this: have you had in the DNA context, have you had circumstances where the sort of initial screening that has to happen before the testing is done? Have you had circumstances where that has proved too much?
So
in New Hampshire, I'm saying.
Yes. So okay. I'm currently litigating a DNA case in New Hampshire. I filed that petition in 2022. It was not agreed upon by the state until 2024. And it only remained in that initial phase because the state wouldn't agree to get past that first hearing. So we were going to have an evidentiary hearing. So it sat for 2 years in the court while the state considered whether they were going to agree to that hearing in the first place. So yes, that hearing has been burdensome and has been causing a problem in terms of moving things forward for us specifically here.
Okay.
That was not on account of the court.
So in other words, you're saying that if I'm understanding, correct me if I'm wrong, you're saying that because the state had some objection to proceeding, that's the basis of the.
So our position on that hearing, and it's very similar to the standard here, was that it would require an evidentiary hearing in order to meet the standard that's been set out in the DNA statute, which is very similar to what you've added here.
Right.
In order to do an evidentiary hearing, we required experts, we required fact witnesses, and we required a discussion about the legislative history in addition to interpret some of the language that was used. And one of the issues was that, we had a number of issues around that, but yes, that was an evidentiary hearing that we were going to have preliminarily just to be given testing. So it was not a hearing that we saw as we just go to court and make an argument. That was going to be an additional evidentiary hearing requiring scheduling and timing and experts and expenses.
Right.
And that's how we were preparing it.
Okay, so I guess, I understand what you're saying, and it sounds like what you're saying is accurate, but I guess my question, though, is, so what's wrong with that? Why shouldn't there be that that standard of having to sort of satisfy this initial threshold before the case goes further?
So in this particular case, our client had us because we were appointed. We were not appointed. We're we just take those cases pro bono. In most instances, that phase would not have an attorney at all. You would not get an attorney until after that was completed. So asking somebody that's incarcerated to be able to secure all of those evidentiary pieces that I just talked about, to be able to get an expert, to be able to get fact witnesses, to be able to get to court with all of those things, and to have discussions with the court when we can't even call the prisons. They can't even negotiate with the state. All of that would have to happen before counsel was even appointed. So that initial pleading requirement has to happen before appointment of counsel in the first instance and under the DNA statute scheme. So that's inaccessible for most folks that are incarcerated just because it's very difficult to do that from behind bars. It's difficult to do the research. It's difficult to contact experts. It's difficult to get their attention. Our client's able to do it because they have us. We're able to do that work for them, but they don't normally have attorneys to be able to do that. So to be able to meet the burden that's set out just by that pleading requirement is essentially unmeetable for folks that are incarcerated on these cases.
Okay. Okay. All right. Other questions?
And to be clear, this is only cracking the door for a petition to be filed. It would still be reviewed. It could still be denied, but this is just allowing someone to have the ability to file.
Mm-hmm. Okay.
And I don't think the bill as it stands precludes the court from saying you don't meet the standard under the statute of limitations even, and saying this isn't new. That's not new evidence. You don't meet the statute of limitations. You just don't even meet that in the first instance. You could still do that here and deny that without a hearing. There's no requirement for a hearing in 526 at all. No requirement for a hearing and no requirement for counsel. So they would still, that's why we haven't added any of the additional standard language from the DNA statute, because it's so difficult for folks to be able to access that in prison. We didn't even put that in here because it's just a pleading requirement. That's why we've left it very broad.
Okay. All right. Other questions? Yes, Representative Turr.
Yeah, just, and this is a non-lawyer on the Judiciary Committee question. Can a new trial be petitioned or granted posthumously for innocence?
That's an open question across the country. I mean, we wouldn't get involved with that because there would be no client for us to represent, necessarily. Sometimes we represent folks and they die during the pendency of the litigation. And there have been cases where we've proceeded with certain issues that are like broader issues. In other words, in DNA cases, like questions about DNA testing have been pursued posthumously when they've been started sort of when the person has died during the pendency of the litigation. We've never started a case after somebody has already died.
Okay, just one quick follow-up.
Absolutely.
The reason I ask it is since we're talking about removing the time limitations entirely, I'm wondering about the possibility of things far down the line coming back and saying, I mean, I can imagine all the things that could be overturned from the past.
So the petitioner is still the person that has to file this, and they would be the defendant. So if they can't file, there's no one to.
And we're not removing the time limit for everybody. It is the very narrow circumstances that they would have to meet all of these criteria to even get in the door.
Okay. All right. Any other questions? Yes, Representative Horrigan.
Do you have to be present in the state or in the United States to file a petition? So what if you've been deported, but you still want to challenge the conviction, perhaps if the deportation was the pretext for the deportation or for whatever other reason?
There's nothing in this bill that talks about that. Whether the court would grant that is a separate question from what we're addressing, because we're only trying to address this piece about how long. I'm not in any way trying to change the court's interpretation currently of who would be able to apply for this one way or the other. So I don't know the answer to how the court would interpret that, and we're not trying to make any changes to how the court would interpret that now.
All right. Any other questions? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Thomas Filardi, please. Spillardi, thank you for being here.
It's also it's a pleasure to be with you here this morning. It's also nice to see my friends from the Innocent Project, as we have met up previously in the last iteration of 141, which was Senate Bill 507. I'd like to go back to a couple of comments that I made in the context of Senate Bill 507, which is this is a really important topic for us to be discussing, and everyone who has touched this issue agrees that it's extremely important to give folks who could be innocent every opportunity to be able to be exonerated, not incarcerated. I say that as a longtime prosecutor. I'm presently the director of the Division of Public Protection at the New Hampshire Attorney General's Office, but before that, for 23 years, I was the Stratford County Attorney. So I appreciate the efforts of the Innocent Project, as well as the many sponsors of 507 and now 141, which is under consideration for you this morning. But what we were told for being the impetus for 507 originally, let's not forget, was that a whole lot of other states have no time limit on when you can file for a new trial. New Hampshire does have a time limit, and so therefore there must be a problem. What I testified to in 507, I want to reiterate today, is this is a solution looking for a problem. The way that we plead these issues in New Hampshire, because our habeas law is so expansive, the new trial statute rarely comes into play. It's just simply not used. Here's the way that folks who want to bring in new evidence would do it. They would use a writ of habeas corpus if they are incarcerated. They would use a writ of corus nobis if they are out of incarceration. Or the way that some people have done it is when I was the chief law enforcement officer, they contacted me. And I will tell you from my own experience that litigants, even beyond scientific evidence, I'm talking about simple recantation, have brought to me compelling evidence which indicates that someone who was previously convicted and long since sentenced should not have been. And so I took action. I don't think anyone in this room should forget that prosecutors are required as ministers of justice to do just that. And the New Hampshire Bar, particularly the New Hampshire Bar of Prosecutors, takes that very seriously. So when I say this is a solution looking for a problem, it's because we have always resolved these issues without this artificial 3-year time limit for filing a petition for a new trial. I want to go back also to Governor Sununu's veto message on Senate Bill 507, because I do believe that the governor's office laid out the problems with 507, which I believe are still inherent in Senate Bill 141, and a way towards a solution. I quote from his July 2nd, 2024 veto message, specifically, the proposed legislation provides infinite opportunity for petitions premised on nothing more than the mere assertion of new evidence, unconnected to any scientific or forensic basis. Additionally and importantly, unlike existing law, RSA 651-D, which provides for a review of DNA evidence, there is no consideration given to victim consultation in the context of reopening these matters, which could potentially, albeit unintentionally, re-victimize individuals. So the governor, end quote, the governor was asking us to look at ways to expand the pretty robust systemology placed into 651D to account for some of these other scientific breakthroughs that could happen. His veto message is just as applicable then as it is today, because the way that Senate Bill 141 is written, Section 3, for the purposes of this subsection, quote, newly discovered evidence, unquote, includes but is not limited to, and then it gives out a definition. There is just simply no way, ladies and gentlemen, that this statute, if passed into law, would not lead to an absolute flood of litigation that would cripple the Superior Court, and because it includes Class A misdemeanors, would probably be a big pain to the circuit courts as well. I recognize that my friends from the Innocence Project are saying they're just trying to crack the door, but how much water can get through a crack? An awful lot. What I'm proposing is that the way this is written can be modified, and I thank the chair for already starting that ball rolling. And I will say that my colleagues from the Innocence Project have been very good about asking, how could this look better? When this was all under the umbrella of 507, it was referred to a study committee, and I wish that study committee had actually done what we could be doing with this language right now, which is looking at it more carefully and coming up with a way to include more of the scientific disciplines that we might want to include than just DNA, which is in 651D. So we're all almost on the same page. But I simply cannot come here and tell you that this is the way to accomplish the goal that we all want to accomplish, which is protecting the constitutional rights of men and women who are accused of crimes in the state of New Hampshire and the United States of America. So I would ask you to strongly consider Governor Sununu's veto message. Consider having a committee that would look, which would include all of us stakeholders, that would include the feasibility of expanding the protections in 651D to include exactly what the Innocence Project is trying to do here with this proposed legislation through Senator Gannon's bill, which again, I appreciate him bringing it forward. We need to keep talking about this. Scientific breakthroughs are happening all the time and we need to stay current. We've done a really good job with DNA. Maybe we could be looking at other disciplines. So on behalf of the Department of Justice, I'm asking you to give that serious consideration. The consideration to victims of crime who every time one of these petitions is filed with very little requirement, there's requirements on the back end to be considered, which are in 526, but there's no conditions on the front end. You just simply have to say, I've got some new evidence that needs to be docketed, needs to be scheduled. A prosecutor's office needs to respond to it. There's a question or a scenario about how one of these sat for 2 years. Sure, it sat for 2 years because in order to do a proper investigation of this, you have to get experts. Those experts are costly. There's not a lot of experts. It just takes time to do all these things. If the door is cracked the way that the proponents say it's cracked, those are all the things that will have to happen each and every time on the front end just to get to the point of, do we have a statute of limitations issue? Do we have some other issue that would bar this cause of action? There's a lot of front end work that goes on to each one of these cases. The way this is written, there might just be a way to tighten that up and take away that procedural concern, which is inherent in the way the legislation is currently proposed to you. Those were my comments, and I'm happy to take any questions if there are any.
Thank you, Mr. Floyd. Questions? Yes, Representative Birch.
Thank you, and it's good to see you, sir. It's been several years. I'm frankly a bit puzzled, so perhaps some data might come forth. You express at the beginning, hey, nobody wants potentially innocent people not to be able to get back in court. At the same time saying, no problem here, let's move on or let's talk about it. Or you can call a prosecutor and that prosecutor will be glad to take a look or not. Do you have data in New Hampshire for, let's say, the past 5 years? How many cases of this kind of alleged miscarriage of justice have been brought to the court's attention, and how many cases specifically have been granted relief? I'm talking about the floodgate argument. Whether are we having a floodgate? Why do you suppose we might have a floodgate? You know, where are you coming from? I want to know actual numbers.
Sure. Well, this would 141 would cause the floodgate. It would give everyone who's, as the chairman said, has a lot of time on their hands, a new way into court when maybe their habeas corpus has already failed or their a timely motion for new trial has failed because of ineffective assistance, and they've exhausted all of those collateral rights to their direct appeal. This would give them, without really having to do much of anything, they could just simply say, I have newly discovered evidence, and all these things would have to happen. It would have to move through the system. Your question to me is, what's the data on this now, which is, there's a lot of post-trial litigation. Almost everyone who has exhausted their direct appeal to the New Hampshire Supreme Court file some sort of habeas claim or ineffective claim. But they're not doing that under the new trial. They're doing that through other avenues.
If I might follow up, I know I
Yes.
interrupted.
Yeah, no, that's fine.
You just said that almost everyone that's been convicted and has gone through other processes files a habeas. Can you give us the approximate number of how many people have been convicted of crimes in the past 2 years, and how many habeases have been filed?
Are you asking for me that now?
Well, you say almost everyone. So
Yeah,
I
in my
assume-
experience, I handled all the post-conviction litigation in Stratford County, and nearly everyone, when they exhausted their direct appeal, filed a habeas petition or an ineffective claim because their counsel had done something wrong.
Okay.
There's a lot of post-trial litigation, post-conviction litigation.
I'll just simply ask if you can send us the data on overall number of convictions for
From whom?
crimes
From the Superior Court?
from the Superior Court, from the AG's office.
Number of
if you-
Habes?
If you handle the habeas.
I don't have it, but I can ask the court for it. Number of Habes. Sure.
And you hopefully have the number of habeases, so we can see if that's almost all. Thank you.
All right, Representative Smith.
Thank you for taking the time to appear before us today. I'm a little confused. We hear a lot in judiciary about how if we do something, all the gates will open and heavens knows what will come flying in. And almost never has anyone been able to provide the substantiation to demonstrate that. And I understand the problems and I understand the inability to be able to predict the future. But as I listen to you, it seems to me, and tell me where I'm wrong, that the Attorney General's office sees clearly the way to resolve this issue, and but wants the legislature to guess at what that solution is. Can't you come before us and say, if the language were to say X, Y, and Z, that would resolve your concern?
In some form or another, probably. I've been instructed that I'm not to be writing legislation. I write litigation all the time, but I'm not to be writing legislation. But I am here to try to provide to you an issue that is clear to us, which is if this language includes, but is not limited to, if that's included in this bill, you are going to have a flood of new trial motions, whether they are supported or not, which will have to be dealt with.
Thank you very much for that. And that would then mean that the information that you would give to us, as requested by my colleague, Representative Birch, would demonstrate that. And if in fact the flood already exists, then what difference does this make?
This would be a whole new wave of litigation. Remember, you can't file successive habeas corpuses. So if you raised issue A in a habeas corpus and that was denied, now you can raise issue A in a whole new form if this were to be passed.
Thank you.
Yes, Representative Horrigan.
Yes, Attorney Velarde, are you addressing merely the relatively brief bill that the Senate sent over, or the proposed amendment, which is about 4 pages longer? And so were you just addressing the Senate bill? I don't know, like Attorney
Yes,
Musso gave
Yes,
some very
thank you for the
detailed
clarification.
commentary
Just
on that.
141,
Yeah.
which you all have this morning. I am grateful to the chairman for preparing something else. I want to take that back and have people at DOJ look at it and give some studied feedback to you.
Oh, yeah.
Other questions? Yes, Representative Turr and then Representative Birch.
Yeah, thank you, Mr. Chair, and thanks for taking the question. At the beginning of the testimony by others, my understanding was that many other states don't have this current 3-year restriction. So I feel like those states might be sort of the place where we could answer the questions about whether or not there would be a flood of these, and what types of language would or wouldn't lead to that. And I'm not sure if you're familiar with how this is played out in any of those states, and whether there's examples along the lines of what would or wouldn't lead to the outcomes that I think you're suggesting.
No, I appreciate the question, and I don't have a direct answer for you, though. I have speculated that those systems of dealing with these post-conviction issues that can and do arise is dealt with in just simply a different way than we have dealt with it here in New Hampshire. But they are still parallel tracks of folks proclaiming their innocence being able to litigate those post-conviction rights. They're just called different things. I have a feeling that new trial laws, in other states might be used more often than they would be used here in New Hampshire, because we have a pretty strong case law body of habeas corpus law.
All right.
I just don't.
Manos, and then
The direct
Representative
answer
Birch.
is I don't know, sir, but that's my speculation.
Representative Manos, and then Representative Birch.
Thank you, Mr. Chair, and thank you for taking my question. I wanted to know how you visualize this working. So somebody who's incarcerated would file a pro se petition, let's say in the Superior Court, and then what's your view on what would happen procedurally from there, and particularly with the appointment of counsel?
So the case would get docketed because, the courts would have to figure out whether there is a right to appointment of counsel. Many times there would not be that right. So we'd have to figure out whether this is falling in a bucket of having counsel or not having counsel. Let's assume that it does not have counsel. The prosecutor's office would have to answer the petition, have some legal answer to why the petition should be granted, denied, or otherwise. And then the court would have to schedule some sort of hearing, probably a status hearing, to say, what are we talking about? What is this? Is it raising a constitutional right? Is it raising something else? And then the court would schedule something else, maybe a hearing on a motion to dismiss, maybe an evidentiary hearing. We would have to figure all of that out. In 651D, those guardrails are built for us. So we would have to figure out, what does this new trial track look like?
Follow up?
Yes, thank you. Why is there a question in your mind that the convicted person would not be entitled to counsel? Why is there a question about whether they would be entitled to counsel?
There is no right to counsel for many post-conviction claims.
Representative Birch.
It would be in the discretion of the court.
Thank you, and thank you again. Let me approach this idea of a floodgate from a slightly different way. As you know, elsewise in your job, I'm sure, due to the litigation in court cases on the subject of the Laurie list, there are increasing number, one might say a flood, of claims established that folks have been convicted while exculpatory or potentially exculpatory, Brady, Giglio, whatever, material have been withheld. There are a lot of those cases. They're reported regularly in the media. Moving to our bill here, if hypothetically there are a flood of 100 cases brought because of this bill, and let's say 20, 25 turn out to be meritorious, is that a bad thing?
Of course not.
Thank you.
Other questions? So, Mr. Velarde, I just want to make sure that I'm understanding. One of the things that you mentioned, and I know is not, at least in the draft is some provision in whatever bill is, would be considered dealing with the victim, considering what the impact of any such motion would be on the victim. Is that correct? You think there should be that should be addressed in some fashion?
We might have to look at 21M, which is the Victims' Bill of Rights, to make sure that that the system is informing victim survivors that this new thing has been filed. I mean, that would probably fall right under 21M.
21M.
I'm not sure that would need to be legislated any further than it already has been. It would just be another post-conviction tick of the box. We already notify victim survivors of any post-trial of the appeal, of any collateral pleadings for post-conviction relief, of 65120, of earned time credits. There are a number of things that these cases keep stretching further and further in their life in the eyes of victim survivors, and we notify them of all those things.
All right. All right. Any further questions? Yes, Representative Bergeron.
Thank you, Mr. Chair, and thank you for being here. I just, I wanted to know if you had already mentioned this. I do apologize, but what is the average time you think, and I don't know if you have that kind of data, as far as extending the time? What would be a typical longer than 3 years that it would take for somebody? So 3 years seems kind of a tight schedule, but I was just curious that's my question to you.
It is very different for each case. For example, I've had motions for a new trial that have been filed before I've done the sentencing on the jury conviction, and some have come longer than the 3 years after that direct appeal. So it varies greatly. It really depends, I think, on the petitioner and the eye of the beholder of the attorney who is assigned to that case.
All right. Any other questions? Seeing none, thank you very much, Mr. Velarde. And I definitely would appreciate it if you and your colleagues would take a look at the proposed amendment, and I'd love to have your comments. I think we probably will. It's likely we will exec this bill a week from today. So to the extent that gives you a time frame, I'd appreciate that.
We'll do that. And I want to assure the committee that the Department of Justice will continue the dialogue with other interested partners to try to make sure that we are putting forward the best thing for this committee to consider. Thank you very much.
Great. Thank you very much. Next, I'm going to call on Representative Bashir.
Thank you, Mr. Chair. Thank you, members of the committee. For the record, my name is Representative Buzz Schur. I represent Portsmouth Ward 3, Rockingham District 26. A little background that applies to what we're talking about. I've been involved in the New Hampshire criminal justice system for, unfortunately, 44 years, a little over 44 years now. So I outdate most everybody in that involvement. I was a public defender for 13 years before I started teaching at the law school 31 years ago. And I represented people on everything from juvenile to capital case. So I'm very familiar with the New Hampshire criminal justice system. I've represented people on motions for new trial. I've represented people on habeas corpus petitions. I've represented, unfortunately, many people who have been convicted, a few of whom have filed motions for new trial. I want to share with you, I don't want to repeat what the two people from the Innocence Project have talked about. They're much more compelling than I am in that matter. I will point out for the committee that I've worked on at least 2 Innocence Project cases, one of which lasted for 13 years with a negative outcome. Several years of that litigation involved it involved trying to get post-conviction DNA testing, and some of the years of that, 13 years, was involved in just getting the court to recognize that we were entitled to a hearing on a motion for a new trial, given it was past the 3-year limit. So to say the least, I've been around. I'm going to, and I apologize for the order in which I'm going to take this. I'm just going to really address things that have been said, questions that have been asked from my perspective. I appreciate the Attorney General's Office, Department of Justice, weighing in now. I will point out that the Attorney General's Office did not weigh in last session when 507 was up for consideration. They didn't testify either in the House or in the Senate at hearings. They didn't testify in the Senate this year on SB 141. So the deep, profound concern about the floodgates opening needs to be put in perspective. The majority of motions for new trial that I've seen have involved ineffective assistance to counsel. That's the most common pleading you see in motions for new trial, even those within the deadline, and those I would assume would be, if the deadline were extended, they wouldn't fall within the language of 141. A motion for a new trial based on ineffective assistance of counsel is not an allegation of newly discovered evidence. That is not the case. So appreciate, I've testified as an expert witness in a number of ineffectiveness claims on motions for a new trial, and so I'm very familiar with the frequency of those. Second, I'm going through this list, and I apologize. I believe the Victims' Rights Statute already allow victims to weigh in at an appropriate time. And I don't think there's any victim in the United States that if it were determined that the wrong person was convicted, that they would have a problem with that, because what it would mean if the wrong person was convicted, it would mean that the person who committed the crime was still free. So I need, that perspective needs to be paid attention to. I apologize for this. The statute, SB 141, as it's written, requires that the motion allege newly discovered evidence. I'm not aware of any Superior Court judge, or for that matter, District Court judge in New Hampshire, that if the pleading, the pro se pleading said, I got newly discovered evidence, I want a new trial, that they wouldn't just deny that out of hand. It would be, I think, implicit in what is written in 141 is that the petition, be it through a lawyer or a pro se defendant, allege what the newly discovered evidence is. And the language of Section 3 of 141 I think that makes it almost explicit that they would have to make an allegation of newly discovered evidence. So unlike what the Department of Justice said, it would not be the case that there would need to be a hearing of any sort or even a response by the prosecution on a petition that simply said, I want a new trial because I've got newly discovered evidence. So I think that would reduce the number of petitions that even would get to anything close to a hearing. as some on the committee know, when I was a public defender and after I was a public defender, my expertise was in the area of forensic DNA evidence. So I was one of, if a prisoner was alleging that DNA evidence would exculpate them, very frequently they would contact me, and we would have a conversation. I'd go and see them, and process it. There are just not that many cases out there where people who have gotten past the current 3-year motion for a new trial limit will have any substantive claim in their petition that there is newly discovered forensic testimony. There's just not going to be that many people out there. I have not seen a lot of people. I've not had a lot of people from the prison, and I'm very familiar, for better and for worse, with prisoners in the New Hampshire State Prison. I have not had a lot of people reach out to me, or for that matter, the innocence practicum we have at the law school, reach out in terms of newly discovered evidence claims. So I strongly contest the statement by Mr. Velarde that there is going to be this flood of litigation. It's just not going to happen. I know the chair wanted some comments on his draft, and I have some notes on that. Again, I apologize for just jumping around all over the place.
Yeah,
but-
I mean, I certainly appreciate your comments, and either now or, if you have, obviously, I know that I sort of sprung this on you this morning, and so, we're not, as I said, we're not execing this bill till next week. If you have further comments, I'm all ears, and I'm sure my committee members would feel the same way.
And I'll work on that. I'll make what comments that come to mind now. I'm used to having students spring things on me all the time, so not saying I will treat the chair as a student, but that would be entertaining.
I'm sure I could use it for sure.
But let me say one more thing before I get to the amendment. It's been my experience over 40 plus years in the criminal justice system in New Hampshire that I have never gotten a state court to consider a habeas petition unless it alleges a constitutional violation. That's just not been my experience. I have tried on a number of occasions to get courts to consider a habeas petition when there's not an allegation of a constitutional violation on it, like an innocence allegation, but I've never gotten a court to do that. The habeas statute doesn't say that explicitly, but all the federal law on habeas says there's got to be a constitutional violation, and even some constitutional violations are not subject to habeas petitions. But so I agree with the chair that the constitutional violation language is not in the state statute, but that's been universally my experience, that it always, and so the alternative is particularly for innocence claims, the alternative is a motion for a new trial. But even under this statute, if this amendment, under SB 141, if somebody's only claim was innocence, and they were not alleging that their claim of innocence, they have newly discovered evidence that backs up their claim of innocence, they're not going to get a hearing on this. It's a really limited language. The really controlling language here that makes this that means we're not going to get a flood of litigation is the idea of newly discovered evidence and the implicit requirement that it be articulated in the petition. I think the chair knows, I certainly know, other lawyers on the committee know that no judge is going to give a person a hearing on a motion for a new trial when they just say, I got newly discovered evidence, and leave it at that. It's just not going to happen. So, to the amendment, I agree with the people who testified from the Innocence Project that it would be great that to do a more comprehensive review of habeas petitions, of motions for a new trial, in more than newly discovered evidence, circumstances, in allegations of innocence. All of those things are incredibly important, but that's a very complicated and albeit important thing to do, and I'm more than willing to work with this committee, work with the Innocence Project, work with the Department of Justice, but we can't do that in a week. So I think this is a good first effort on the part of the chair to do that. My concerns are the blending of language in the post-conviction DNA testing statute with the chair's efforts here. I testified when the original post-conviction DNA testing statute was proposed, and several changes were made based on my recommendation, and I've been involved in that. One of the concerns that we always have is the tension between the floodgates opening up in a broader habeas statute or a different habeas statute, habeas corpus statute, and in a different motion for new trial. There's the tension between we don't want innocent people sitting in jail. Even people who have, there's cases around the country. One study by the Innocence Project said that over 25% in the first 100 plus cases of people who were exculpated by forensic DNA evidence, over 25% of those cases were people who had either pled guilty to the charge or had confessed to the charge. So I don't want to understate how important the goal is to better create procedures that pay attention to people who have been wrongly convicted without opening the floodgates. And that's a complicated tension. Just for example, on the court, excuse me, I'm still in my mind, the chair is the court. And on the chart, the chair's amendment on RSA 534-A:3, the bottom of the first page, explain in detail the petition has got to, who's petitioning, making an innocence petition, has got to explain in detail the grounds for reasonable belief that new forensic testing or the new scientific understanding as described in Section 2, in light of all circumstances, will demonstrate that the petitioner did not commit the crime. The difficulty with the language is twofold. One, it comes too close to showing you got to prove to us you're innocent before we give you a hearing on the motion for a new trial. That language comes too close to that kind of standard, number one. Number two, no prisoner, with one exception, and he's now deceased, with one exception, no prisoner I have had experience with knows how to make that kind of showing. And this is at a point when they would not have counsel. This is before they would have counsel. So I don't say, I understand why that language is there, and I understand the chair's efforts there, but it's that balance is out of whack in that language. That's of concern. If I could have a second to look at my notes. I think I'm getting there. I think I will, other than saying, I think we can deal with issues that are live now for organizations like the Innocence Project by passing SB 141, perhaps a small amendment that makes the requirement of a showing of a specific statement of what the newly discovered evidence is. But other than that, I think let's pass SB 141. It doesn't prevent us from all getting together and doing what in the long term everyone wants to do, is find a better balance between innocent people spending their time in jail and not overloading the system. With that, I'm more than willing to take questions.
Representative Page, or Representative Smith? I'm sorry, Representative Smith.
Thank you. I have two questions. Could you answer the first one just yes or no, Representative? I know that's very hard for you.
The law professor in me makes that very difficult.
I understand that, but you know, we're all struggling on this. Do you believe that the criminal justice system in this state is perfect?
No.
Let the record show that that was proper answer.
Could I get a transcript of the record too?
Yes. The second question is, do you believe that this bill is a very narrow bill designed specifically to meet a very narrow set of circumstances without seeing the necessity of changing this narrow bill into one that attempts to restructure the perhaps damaged criminal justice system?
I'm going to start with a single answer. Yes.
Thank you very much.
Boy, that was hard.
Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. I wanted to know your view on the possibility of incorporating SB 141 into the post-conviction DNA testing statute 651D.
I think that would be a mistake because the post-conviction DNA testing just relates to post-conviction DNA testing, and there are other kinds of scientific evidence like bite mark evidence, like fiber analysis that over the years, like arson analysis, that over the years have been in many ways debunked. And if we limited SB 141 to just the post-conviction DNA statute, it would do a disservice. There's not many of those cases, but they exist, and I don't see any reason not to incorporate them in SB 141 rather than just limiting it to post-conviction DNA.
Follow up? Go ahead.
Thank you. Could we not broaden 651D to, excuse me, incorporate the standard of any newly discovered scientific evidence or new scientific understandings? Could we not incorporate that into 651D?
It would be my, if I were the ruler of the world, it would not be my preference to do that. It starts to get complicated. And the idea behind SB 141 is it's a simple standalone proposition. And I think in the broader reconsideration going forward, in the hopes that SB 141 was passed, that is certainly something worthy of consideration, the interplay between that and what's going on with motions for new trial now.
Other questions? Yes, Representative Tur.
Yeah, thanks, Mr. Chair, and thanks for taking the question. Similar question to what I asked Mr. Velarde earlier. Given your long practice in the law, are you familiar with other states that have no cap on the time limitations and any negative consequences that have happened as a result of that?
I'm not familiar with states who have had negative consequences that have disrupted disrupted the criminal justice system in those states. You know, there are some prosecutors' offices in states that have put together integrity units, the goal of which is to, on their own, without even people, defendants or lawyers petitioning those units, have taken into consideration, have gone back and looked at old cases to see if there's problems. They've also looked at those when defendants have raised the issue, and that's been a very positive development. And this is my effort to give a longer answer to Representative Smith's question. It's everybody now knows that we can't have a perfect criminal justice system. We know from the exculpations that have occurred based on faulty eyewitness testimony, based on faulty forensic testing, based on faulty investigation, based on unreliable snitches, so to speak, that we can never make the system perfect. And depending on what state you're in, depending on what prosecutor's office you're in, there have been more aggressive efforts to deal with these outside filing a motion. And that's been positive. Yeah, there's been more work, but if more work is the price for less innocent people sitting in jail, I'll make that trade-off.
Other questions for this witness? Seeing none, thank you very much, Representative. Sure.
Thank you.
All right, is there anyone else who wishes to testify on SB 141 FN? Seeing none, I'm going to close the hearing on SB 141, and I'm going to open the hearing on SB 268, and I would first like to recognize Senator Kevin Avard, the prime sponsor.
Thank you, Mr. Chairman and committee members. I'm the prime sponsor. Not of this one. SB 268. And I thank you for the opportunity. Again, Kevin Avard, District 12, Nashua, Hollis, Brookline, Mason, Ridge, New Ipswich, Greenville. And so this bill basically, it provides a definition for biological sex and provides that the certain designation by biological sex does not constitute unlawful discrimination. In essence, this bill basically allows public and private institutions to protect women-only spaces. It's an enabling legislation. So it allows, if you're a school and you want to designate a particular area specifically for women, biological women or biological men, you will not be held responsible for, you will not be held, you will not be able to be sued for discrimination. This bill basically mirrors one of the other bills that you folks have already heard. And I don't want to belabor the whole situation here, but people are crying out for some protection for privacy for women, whether it's in the bathrooms or schools or the prisons. And this bill provides for that. It doesn't mandate, but it allows a private institution or public institution to protect women's spaces if so inclined, whether it's a school or a private business, a restaurant. And with that, I'll take questions.
Questions for this witness? Representative Horrigan.
Yes, I might have a follow-up. My first question is, you say there's a definition of biological sex, and I'm going to guess it's on page 2, lines 14 through 16. So I'm a little bit baffled by it because it seems sort of circular. And of course, it also leaves people who are neither male nor female, intersex people. So am I misreading it, or can you clarify?
You're reading it
That's
correctly.
the definition? Okay.
You're reading it correctly.
All right. I have a follow-up to.
Yep.
Also, with that same section, we're referring it to the Commission on Human Rights, which may or may not continue to exist, depending on what happens with the budget bill. So do you have any thoughts on what happens if this passes and then also the Human Rights Commission is discontinued. So
I'm not a fortune teller. I have no idea.
me neither. So thanks.
Other questions for this witness? Yes, Representative Smith.
Thank you very much, Senator, for being here. In your testimony, you referred several times to protecting women. I don't see anything in here, and I don't know if I'm missing it, about protecting men.
You can, if you'd like to add that, that'd be great.
Could you tell me why you would differentiate between, if I could follow up, differentiate
yes.
between protecting women and protecting men?
Well, I think men are a lot stronger biologically than women. And, you know, we had some testimony when I brought this before the Senate. And I was listening to everybody who was testifying. One woman walked into an elevator, and she said there were 3 men in that elevator. And it made her nervous. It made her nervous. And Senator Abbas said, well, what if those 3 men were in the bathroom? She said, that would make me very nervous. So the follow-up question is if they were, if they were dressed like a woman, would that make you feel any safer? The answer is no. We're hearing more and more testimony where women are feeling that their privacy is being invaded by individuals who are biological males. That's the outcry that we're hearing. Some people are whispering it because they're afraid to speak up and to be being chastised by other individuals that do not have the same values that they have. So the women are definitely speaking up. And this legislation is answering that call. We haven't heard a whole outcry from men, but if you're willing to put that in there, we'd be happy to add that as well.
May I ask another question?
Yes, certainly.
Thank you very much. Senator, are you aware that there are any number of countries in this world that have made very clear that women and men should be kept separate, and women must, for example, always keep themselves completely covered, not necessarily to protect the women, but to better honor the needs of men, that women should not be allowed to be educated because they have to be protected, that women should not be allowed to work, that women should not be allowed to ride in public transportation in the same place that men. Is that something that you would like to see happen here in the United States so that women are consistently protected from men?
Representative, with all due respect, I think that is the most outrageous question that you could have asked me. This is America, and I find that to be offensive, that doesn't even reflect anything in this bill. So when I walk into the Capitol and I come out of a committee and I see 4th grade girls in the bathroom, I don't want to see a 6-foot man in that bathroom with those little girls. I don't want to see that. And most people don't either. It is not a place for a male, a biological male, to be in there, whether they're suffering from a mental illness or if they have evil intent. And we know that gender dysphoria is a mental disorder, and we're all concerned about mental illness. So we can't tell if there's somebody who has evil intent or has a mental illness that is in that bathroom. That is so far removed from this bill, and it's offensive. Thank you.
Just one more. I want to apologize to you, Senator, if in any way you thought that the question was offensive or insulting. What I am trying to do is learn more and more about what your perspective is so that I can understand it. I referred only to situations that do exist in the world around us so
But
that I
not here.
didn't invent it. Well, could I ask you just one other question?
Sure.
The age at which girls reach puberty varies dramatically. Do you think that in order to protect young girls, we should determine that there should be a separation in locker rooms, in bathrooms, between girls who have reached puberty and girls who have not reached puberty?
Well, let me just draw you back to the bill. The bill allows private institutions or public institutions to make a determination on biological sex in a bathroom or locker rooms or the prisons without fear of a lawsuit. That's what this bill does. That has nothing to do with your question.
Thank you very much for helping me to understand it better.
Senator Perez.
Thank you. Thank you for taking my question. I have made this statement multiple times in my short tenure. Do you believe, and there's a question at the end, we cannot provide equity for 100% of the people 100% of the time, but we have an obligation to provide safety and comfort for the majority, and especially in sensitive situations. Do you agree with that statement?
I do.
Thank you.
Other questions for this witness? Representative Turr and then Representative Birch.
Yeah, thank you, Mr. Chair. Thanks for taking the question. In the previous presentation of this bill and this one, I remain sort of perplexed at the lack of specificity with which biological sex is introduced into a context where it can allow any organization or even any individual to direct someone to do something. So in a specific instance, are you aware that it is possible for someone to have, say, female genitalia, but outward characteristics that appear male, such as a beard or male musculature, through the use of legal therapies?
This bill has nothing to do with that. This bill says that an organization, whether it's public or private, can designate a particular area for biological sex or in sports. So, sure, there could, but I'm not really sure how that pertains to this bill.
Well,
This bill basically says that they can't be sued for discrimination, but it allows them to make the designation of a bathroom for biological males and biological females, whether in sports or in a prison.
right. So, may I follow up?
Yes.
In that situation that I just outlined, it seems to me as though two different organizations could make the opposite determination of which bathroom an individual like that should use. Is that not true based on what's outlined here? Those are two different biological bases for determining sex, if I'm correct, right? One is based on secondary sexual characteristics like beards and musculature that are the result of hormones. The other is based on genitalia, and those can be inconsistent for one individual at a given point in time. So to me, it seems this would allow two different organizations to treat the same individual in opposite ways. Is that not true?
That is not true.
Okay,
This is
explain,
to
please.
do with biological sex. It has to do with the DNA. There's nothing confusing about that.
Okay.
Period.
Okay.
We've known this for thousands of years, and there's nothing confusing about that.
Okay. One more follow up, Mr. Chair?
Sure.
So you just actually answered, I think, part of the question that's been missing from this. You said it's based on DNA. Is that your preferred interpretation of biological sex? And just to build on the question that I was asking a minute ago, is it not true that someone could have XX chromosomes and also be outwardly exhibiting the characteristics that are associated with males due to legal hormone therapy? And which bathroom would that person use?
So that same person could be, I'm going to stick to the bill. The bill says, based on biological, an organization can construct, maintain, operate a laboratory facility, locker rooms designed used for multiple persons at the same time, even if such an individual urinal stalls are in an apparatus, in athletic sports operation, in sports or in similar activities which physical strength, speed, endurance, in general recognized to give an advantage to biological males. You're going to have to look up the word, biological. In operation, maintenance, and use of a facility designed for usage as a prison, household, houses of correction, juvenile detentions, or commitment centers, mental and hospital or treatment centers. Biological sex, second page,
Yep.
shall mean male and female biological sexes. Not gender dysphoria, not any other definition. It's biological. And I just find it comical that there's confusion about this.
I don't.
It really is. It's comical because we've known for thousands of years what a biological male is and a biological female is. It's pretty obvious. There are cultures which have had differences over time, but our
All right. Other questions for this witness, and I guess I say let's remember that the purpose of is to ask questions, not have a debate. All right. So, Representative Birch.
Thank you, Mr. Chair, and thank you, Senator, for taking my question. And in view of what the chair just said, I won't discuss the fact that for thousands of years we thought the sun went around the earth until it turned out to be wrong. So my question to you is, you gave an example of a bunch of fourth graders utilizing a bathroom, presumably girl fourth graders, and then a person presumably presenting as a male comes in, and that's problematic. So my question to you, using your example and the fact that this is state legislation, so it shouldn't be sloughed off to municipalities, how is this determined on the spot or otherwise, whether that person is a biological male or a biological female for the purposes of going to the bathroom at that point in time? How is the state, through this legislation, going to accomplish that goal, since it seems to be your goal?
Well, the goal is enabling legislation to allow individual business owners, schools, to make that determination as to what the use of the bathrooms will be. That's the purpose of this legislation.
Other questions, Representative Ward.
I guess I'll use the bathrooms at the State House and the fourth graders as an example, but it applies to all sorts of organizations. Here at the State House, we have a fairly, I guess the rules aren't written, but they're fairly clear that people who are presenting as male use the male restrooms. People presenting as female, the female restrooms, we don't bother to check, we don't bother to look under their pants or demand a chromosome test. We accept that. As in the case of the fourth graders, they usually line up. They have chaperones, chaperones of both genders, but typically the girls lined up in the girls' room. From the girls' room, the boys lined the girls' room, and the chaperones, and most of whom are female, not all, and then they sort of set aside that bathroom for the use of the school group until they're all finished. And it would probably be a problem even if a 6-foot man barged into the boys' room, even if and started molesting the little boys. That would probably be.
Representative, I know there's a question here.
Yes,
I'm
so
just waiting for it.
this would, nothing in this would prevent the State House from continuing to run its facilities the way they've been doing, so they're not forced to, take more drastic members. They're not forced to take more drastic measures than what we've already been having, which in the case of State House has worked pretty well. To the best of my knowledge, nobody has been molested in the restrooms, 4th graders or older people either. So, so this would not restrict the 4th grader, the State House, or any other organization from running their restroom facilities the way they've been doing it. So that.
Well, thank you.
All right. Other questions? Yes, Representative Turer.
Thank you, Mr. Chair. I will. Separate sort of issue that I have with this bill is the question of invasion of privacy, which we take very seriously in the state. Is it your impression that this legislation, in order for people to make the determination of where they should instruct someone to go for a restroom facility, or what sports team a school should instruct someone to participate on, that they could request information or other types of revelations from somebody? For example, could a school demand DNA testing or some other proof of your biological sex in order to make the proper determination, or what they consider to be the proper determination? And what are the limits on that?
Well, I appreciate the question, but it has nothing to do with this bill. This bill allows individuals, whether they're a small business owner, a school, or any municipality, to designate bathrooms without being discriminated against, without fear of being sued for discriminating. So that's what this bill does. It has nothing to do with your question, because it doesn't say anything about policing. It says they are allowed to designate these areas specifically for biological males and for biological females. That's what this bill does.
May I have one follow-up, Mr. Chair?
Well, if it, follow-up question, yes.
Yes,
but
and that was a question, I hope.
All right.
And this will be as well. Bathrooms already have designations in terms of which is the men's room and which is not the woman's room, if you want to call it that. This seems to basically suggest that the authority of an entity goes further than just putting a sign on the door. This seems to suggest that they can instruct someone of which one of those would be the proper place that they should go. And I guess my question is, what would be the basis beyond sort of what somebody either looks like or identifies or chooses to do, that they would make that determination if it's not just the sign on the door?
Well, I'll give you an example of what happened here at the State House. There was a big line of individuals who were banging their tambourines and making a ruckus in the hall. One of the assistants to one of the branches of government, not even 5 feet tall, walked into the bathroom, and there was a tall individual with a beard in the ladies' room. She felt her privacy was violated. Said, ladies' room right on it. She walked right out. So she had to go use another bathroom because she felt that that was not being honored. It does happen where individuals who are dressed like a female go into the bathrooms, but are biological males. Oh yeah. I've heard them testify in the committee. So it's happening. And people want results. If somebody's confused about what a biological sex is, they should take a biology test, a biology class. but it's weird that we're here in today's society.
Well, thank you. As the holder of a bachelor's degree in biology, I appreciate that, but I don't think this bill actually does that.
Thank you.
All right. Other questions for this witness? Representative Kutow.
Thank you, Mr. Chair, and thank you for taking my question, Senator Avar. Would it be your impression that utilizing this bill, that a school district could create a policy such as to say that they would base decisions like these based on the original birth certificate that a student might have had? I know my district in Windham currently has such a policy. Would it be your impression that this would allow businesses or school districts or other public entities to develop a policy that they felt was reasonable in order to comply with something like this?
Yes.
Thank you.
All right. Other questions? Representative Birch.
Thank you. That raises the question to me of how much is this bill intended to legitimize or protect actions taken by municipalities, individuals, whatever, and allow them, for instance, for the school to require a DNA test for every incoming student every year. Is the purpose or effect of this bill to provide an umbrella of protection for a wide range, an unlimited range of so-called protective measures that others may say, given the language of this bill?
No, this bill allows schools, businesses, and private businesses or to make a policy without worrying about being discriminated against. It says nothing about taking DNA tests. Has nothing in there at all. It's just so that we can operate, put up a sign and say, this is for women, this is for men. If you violate it, I'm going to kick you out of my restaurant. Don't do it. And they can't be sued.
Other questions for this witness? Seeing none, thank you very much, Senator.
Thank you. Thank you, committee. I appreciate the questions.
Next, I'm going to call on Representative James Kofalt. Okay, I'm sorry. Okay, so he's not here. All right. Next, Representative Alice Wade, please. Let me see how many people. Yeah, you know what? We've given the number of cards I have here and the time, we're already behind. I'm going to, other than the prime sponsor, I'm going to ask that everyone else please limit your remarks to 3 minutes.
Good morning, members of the committee. I'm Alice Wade, and I serve as state representative for Dover Ward 2. And it's not going to happen, but real quick, show of hands, who has their original birth certificate on them or even knows where the hell it is in this entire room?
Yeah,
do you have it on you? Exactly. So before, I'm sure you've already heard me speak on this issue. So instead, I'm just going to tell you a story about a state with a bathroom ban to show you where this path leads us. Danny Davis was an employee at Walmart in Lake City, Florida for 7 years, and she holds several other part-time jobs, including tutoring special needs children as requested. She described herself as a hard worker who's never really gotten in trouble, and despite being a cisgender woman, she happens to naturally be 6'4". Around a month ago, on March 14th, she was going to the restroom on her shift, and no one else was in there. Until all of a sudden, she heard somebody open the door, walk into the room, and a man started yelling. Danny said the man yelled he was going to beat them and he was going to protect his wife or girlfriend from them, while his wife or girlfriend pleaded with him to stop and leave before he got in trouble. Danny froze in the stall and was terrified that the man would try to open it and assault her. She was the only person in the entire restroom, so it was clear the man had seen her gone in and suspected she was a trans woman because of her height. Danny later said, "It was terrifying, and I wish no one else had ever had an experience like that." Eventually, the man left, and she was able to leave the room. She was visibly shaken, and her manager asked her what was wrong. She told them after about the incident and went home shortly thereafter. Less than a week later, she was fired. The reason given her for termination was that she didn't report the incident to a salaried management employee and therefore created a security risk after being harassed. She later tried to appeal the decision, and it was denied. So getting harassed by someone because they thought she was transgender, and she was the one who faced the consequences, not her harasser. People like Danny Davis are getting caught up in the crossfire, and people like her harasser are being encouraged to become bathroom vigilantes because of the false perception that trans people are a threat. If this bill passes or fails, your lives will not get any better or worse because of it. But there are many, many people in this state who will be deeply harmed by the passage of this bill and those like it. Last year, after I heard that a trans athlete was getting harassed at her soccer games, I asked if she wanted us to come and support her and cheer her on. She said no, because all she wanted was to blend in and to play with her friends and to just live a normal high school life. She is one of only 4 athletes trans athletes in the entire state, and it made me cry deeply because that's all she wanted, and that's all I want too, to be left alone. Maybe instead of figuring out the best way to remove trans people from public life, we should leave them alone and focus on the actual issues facing our state. Nobody will get caught in the crossfire if no one is firing at each other. We have better things to do. Thank you, and I'm happy to answer any questions.
Questions for this witness? Representative Alexander.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. The last sentence when you said we have better things to do, I guess I question that because this is an issue that polls consistently in public, like in public policy polls, that people want to protect women. They want to protect women's sports and create a clear biological divide between two. I believe a whole election was decided on one of these issues. So I guess when you're saying we have better things to do, tell me why we should be doing something that only 20% of the population thinks we should do.
So thank you for your question, and I'll address it in a couple parts. So I would challenge the notion of public support on this issue, because if you look at every single one of these bills here in New Hampshire, if you look at the number of people testifying in opposition and the number of people testifying in support, it is completely flipped. It is like 80 to 90% oppose and only 10 to 20% support. Thousands oppose, hundreds support. I mean, I've said this on the floor, but the numbers don't lie when it comes to people who are coming here and testifying. On the note of trans women in sports, I get that when you hear the thought of, a trans woman competing in women's sports, I get that on first impression, you think of that and you think of a 6-foot jacked football player barreling over a little girl. But that's not what's happening. There are only 4 trans athletes in the entire state. Somebody asked Chris Sununu how many he thought were in the state, and he said something like 50. People don't understand what this issue is really like on the ground because we're only 1% of the population, and an even smaller percent are competing in sports. I didn't compete in sports. I was a robotics nerd. But if I had, I would want to have just been able to blend in and play with my friends. And, that to address your question, I get that in sports specifically, there are certain concerns and certain thoughts of maybe you have to be on hormone therapy for a certain length of time because that makes it more fair. And I understand that. And that's what sports leagues had been doing, that they'd been creating these policies around how long you had to be transitioning. And now the state is coming in and giving this blanket, across the board issue. We're passing these bills when it's 4 kids. There's housing bills that matter, that deeply matter. I know you're the chair of housing, and I care about housing too. That's the type of issues we should be focusing on, rather than spending all of this time, hours and hours, on every one of these bills, targeting 4 kids. That's what I mean when I say we're catching people in the crossfire and we have better things to do. I didn't come here to go legislate what 4 kids are doing. Let the sports leagues do that. Why are we trying to have big government come in and solve this issue that's an issue for 4 people? It doesn't make any sense.
Right.
So that's to answer your question.
Other questions for this witness? Representative Hort.
Well, first of all, I've just worked in polling, so the results are very unreliable. It's a lot of it depends on the context, and of course, in this case, too, probably people's opinions are probably shaped on what they've heard. A lot of the information that has been put out there by.
The question is, Representative Hort.
Oh, that was actually my question was a different one. Anyway, so the polling results sides that doesn't mean much to me one way or the other. But with your incident in Florida, isn't it true that this person who was certainly presenting as male, presumably was a cis male, actually did get into the bathroom, did manage to make trouble, did manage to upset at least 2 women, one of whom was his wife, one of whom was an employee who was just taking a break from her difficult job. So even with a law like that in place from Florida, somehow a man did get into the bathroom and did manage to cause trouble. So this law will not prevent that, right?
Correct.
Yeah.
And that's something that the prime sponsor failed to answer, which is how does this get enforced? You talk about biological sex, and even if you say, oh, use your original birth certificate, do you carry yours around everywhere? I sure don't. I barely know where mine is. Are we having people at the door policing who gets to go in? No, we're not. So what it ends up being is people base their assumptions off of just how somebody looks. And I know if you saw me in the men's restroom, you would probably raise an eyebrow much more than you would if I went into the women's room. I know because I've been using the women's room for 6 years and haven't had any issues at all. That's what's at stake here. And part of the issue is that the reason this pulls like this is because trans people are villainized. We're told that we are a threat, even though there's absolutely no instances where an assault like this has happened. Trans people are 4 times more likely to get assaulted than cis women in any context. So all of these, things are based on a false assumption at its core. So that is why we need to be focusing on actual problems and not this fictitious, issue.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Oliver Bonema, please.
Hi, I don't know if you ended up moving me earlier. If you did, I really appreciate it. I have class fairly soon, so I really appreciate you letting me speak earlier. So I just want to kind of, by the way, I'm here in opposition to this bill. I just wanted to kind of disprove a few falsehoods I've heard stated here today. So the whole women need to be protected idea is just based in sexist ideology. We've been determining this for decades now. Second, being trans is not a mental illness. So gender dysphoria, yes, is classified as a mental illness. However, that is not a requirement for someone to be transgender, and it simply refers to a marked incongruence between one's biological sex and secondary sex characteristics and their gender identity. So I also wanted to say biological sex is actually not just a simple binary. It's a bimodal distribution characterized by things like primary sex characteristics. Sorry. Thank you, Representative. It's primary and secondary sex characteristics, primary including things like genitalia and chromosomes, which, by the way, about 1 to 3% of the population is intersex. And secondary sex characteristics refers to things such as breasts, body hair, and fat distribution and muscle distribution, for example. Also, chromosomes don't inherently determine your genitalia and secondary sex characteristics and hormones. This is just kind of the definition of intersex people and can also occur due to various other medical conditions. Also, DNA is not necessarily 100% consistent across every cell of the human body. I'd also like to add that the concern of this bill seems to be predatory men, which is something I am also incredibly concerned about. And I think that targeting trans women in this bill, primarily, this bill is targeting trans women, is frankly away from the point that you're trying to get at, and instead going to hurt a lot of women, especially women of color and gender nonconforming women who may be perceived as men despite not being as such and despite being assigned female at birth. I'd also like to add, I have a couple pieces of specific data from here. So 68% of trans people have been verbally harassed and 9% have been physically assaulted while using a public restroom in the past 12 months. This is according to certain studies. I've submitted digital testimony with my sources specifically. Excuse me. And additionally, 8 out of 10 sexual assault victims are like assaulted by somebody that they know. So I think bathrooms might not be the place where we should be working on this. And instead, maybe we should actually target people who are committing sexual assault and instead focusing on that. And additionally, in terms of the sports thing, one, it's an incredibly small percentage of people. And most, yes, it is. I see you nodding your head no. I have data to back me up on. So with the sports, there is it's an inaccurate understanding of biology. So, for example, being male tends to cause one to have more.
I'm sorry, your time is up. If you want to,
Can I finish that statement?
Yes.
Okay. So being male tends to give one more immediate muscle mass. Yes. However, for example, like with testosterone, however, estrogen tends to give a person more endurance-based muscle mass. And there have been trans people have been allowed in the Olympics for 2 decades, and I would love you to tell me one trans Olympian. I will take any questions.
Great. Questions for this witness? Seeing none, thank you very much. I'm sorry, Representative Perdomo.
Would you please spell your last name?
Bonnema. I understand it's a weird spelling and pronunciation. So.
N or M?
So there's 2 N's after the O, and then an M before the A.
Okay.
Great. Thank you.
Writing it in cursive is a nightmare.
All right.
Thank you.
Next, Representative Heath Howard, please.
Thank you, everyone. Thank you, Mr. Chair and committee members. For the record, my name is Representative Heath Howard. I represent the towns of Stratford and Barrington in Stratford District 4. And I wanted to address some of the things that the prime sponsor, Senator Avard, said, because I do think that he did answer the question as to how this bill is enforced. He said a number of times that it would legalize the discrimination of people based off of the owner. So hypothetically speaking, if I'm the owner of a business, I could say to any one of you, you're too effeminate, you're too masculine to be using this bathroom. And I could kick you out of my establishment without any issue, because that's my right. When we open the door for any sort of discrimination, it opens the door to a lot worse of a much worse society, because we're now allowing people to be subject to the whims of others, and the identities that people carry may not necessarily be fully apparent. There are masculine looking women, there are feminine looking men, and these people are going to be affected because they're going to be told, you need to leave, you need to go use a different restroom, you need to go use a different facility, you need to leave this property. And that's not acceptable. We're opening up a door, we're opening up a Pandora's box. And I'm not necessarily sure we're going to be able to close that. Thank you. I'm open to any questions.
Questions for this witness? Representative Manos.
Thank you, Mr. Chair. Thank you, Representative Heath. I wanted to ask some practical questions, which is, this bill is permissive. And so, for example, if one school system decides that trans kids cannot play on the team, and another school system decides that trans kids can play on the team that they identify with, what happens in that situation when the 2 teams play each other?
I would not necessarily be able to answer that. I'm not necessarily certain, because as we heard from the prime sponsor, it's not necessarily clear. It's up to the individual entity. So if we're talking about the state as a whole and whether or not, the governor wants to sign an executive order per se, banning all men from women's restrooms, that would potentially be legal and binding under this legislation that we're passing. I don't necessarily know the full extent of the impacts and as I said, of this type of legislation, because we're opening up a Pandora's box. When we open up any sort of avenue for discrimination, we open up the risk of subjecting people to harms against their own civil liberties.
All right. Other questions for this witness?
May I follow up? Thank you. So, for example, another example in my mind would be a county complex. So one county complex, the courthouse and the associated facilities, decide one policy on people in bathrooms, trans people in bathrooms, and another county decides differently. And one person goes from one county to another county, and they're treated differently in the two counties. How could you comment on that?
I mean, I think that we're again in a situation where we're opening up a Pandora's box, where, especially as we heard from previous testifiers, trans people, especially trans women, face higher rates of sexual violence than other groups. And if we, per se, move somebody where one county says it's okay that they're in the women's prison and then move them to the men's prison, they're likely going to be subject to various types of sexual assault. So in my opinion, it's something that, again, opens up a Pandora's box and risks a lot of people's civil liberties.
All right. Other questions for this witness? Representative Perez.
Thank you. Thanks for taking my question. Do you think it's all right for my granddaughter, hypothetical, to be afraid to go into the bathroom at her middle school, or to stop going into the bathroom in her middle school? Do you think that's okay for her to have that fear as a healthy child? Is that okay for her to have that fear?
I don't think that's okay, but I mean, when I was growing up, I was subject to bullying, per se. I was afraid to go to school. Was it okay for me to then stop going to school? No. And it's something where we're excluding other people based off of whims, as I said. And when we're talking about children, because we keep getting into this discussion about fourth graders and young kids, when we're talking about young kids, we're talking about them going to the bathroom, and what do they do when they go to the bathroom? They go to the bathroom. We're not going to necessarily see a situation where one child is being assaulted by another child, and if they are, that's going to be directly brought up to the school administration. So if they are being directly harmed, if they feel threatened, if they feel that they're in danger in some way, shape, or form, that's something that needs to be handled by the school administration and actually dealt with. Because by doing this, we're shifting the blame from an individual to an entire class of people. So if your granddaughter is afraid of going into the bathroom, I would assume it's because of a singular student, and that student needs to be dealt with. However, we should not subject an entire group of people to the whims and speculations of others.
Other questions?
Follow up on that?
Yes, but not an argument.
No, I'm not going to argue with you. So you think it's all right. So if this is hypothetical, my grandchildren are older. So if my grandchildren goes to the school and says, I have a problem, I don't feel safe in this bathroom, and that person is a trans, what do you think the school is going to do about it? If the school does something about it, you don't think they're going to get in trouble because that person was a trans? You don't think that's going to happen? We need to protect the majority of people. And that's what we need to protect. Thank you.
I wholeheartedly disagree.
I don't think there was not a question.
There was not a question, but I wholeheartedly disagree.
All right, so next, any other questions for this witness? Seeing none, thank you very much, sir. Next, I'm going to call on Bill Hamlin, please.
Thank you for your time. I'm Bill Hamlin.
Microphone? Oh, microphone. Please turn it, make sure the red is, there you go. Thank you.
Can you hear me now?
Yep.
Okay. I'm Bill Hamlin. Among other things, I was a candidate for CD2. Yeah, I live in Hanover, New Hampshire. I would like to point out for everyone in this room that I have a driver's license here, New Hampshire driver's license, and it has in bold letters M. So it's not that confusing for the state of New Hampshire to define what is a male and what is a female. So for anyone in this audience that's confused, check your license. I would like to ask the committee respectfully, how many here have a daughter or a granddaughter? By show of hands.
I'm sorry. No,
Okay.
You can testify. We asked the question. Okay,
Sure.
thank you.
Fine. Sorry about that. Well, I can tell you I've got 2 daughters, and both of them were swimmers. My oldest daughter in 2020 was admitted to Dartmouth College, and she was invited onto the swim team. Dartmouth canceled the team, and I led the fight to bring it back through a Title IX lawsuit, and I learned a lot about Title IX in that process. After we got the team back, my daughter was invited to be the captain of the swim team. And I had to go and watch her compete in the Ivy League championships against a hulking giant male from UPenn. And I was bullied into silence. It was absolutely horrifying. So I'm in favor of any bill that strengthens women's rights in particular. But I think there's another issue here that's very important. What I learned about in this process wasn't just that the swimmers were bullied and the parents were bullied into silence. It's what goes on behind closed doors. Because the coach and the coaches bullied all of these students, and you read about it and you hear about it from Riley Gaines, what went on, what she faced. These kids are bullied. So when someone says there's only 4 trans or 10 trans in New Hampshire, and why should we care so much? It's not just because of those 4. It's because of the ideology that they represent. It's because of the teachers, what our teachers are teaching our children behind closed doors. That's what we're up against. It's the entire ideology, the madness that these biological men should be allowed to compete in women's sports. It's insanity. So we're fighting, Jonathan Haidt is one of the leading moralists of our age. He calls it, there's a book called Popular Delusions and the Madness of Crowds. We are rising out of a period of cultural madness. Call it the woke mania. And that is what we are ultimately fighting against, this idea that boys should compete in women's sports. Now, slowly, our country is coming around.
Your time is up, sir.
Okay.
Okay.
Any questions?
Questions for this witness, Representative Tur.
Are you aware that in New Hampshire you can have M, F, or X on your license? And I'm looking at the application for driver's license right now, and under gender it says male, female, or other.
Yes, I'm aware.
All right, other questions? Seeing none, thank you very much, sir. Next, I'm going to call on Nancy Brennan, please.
Thank you for your time.
Thank you.
Good afternoon. Thank you for taking my testimony. Last year, Governor Sununu vetoed a bill similar to this one because he said it runs contrary to New Hampshire's live free or die spirit, and that it seeks to solve problems that have not presented themselves in New Hampshire, and in so doing, invites unnecessary discord. But times have changed. Our world has changed. References to transgender people in history and government documents are disappearing. It's hard to keep up with all the executive orders and changes in policy that target trans people, their health care, their very right to exist. I have a history lesson. In the 1930s in Germany, before the Jews were targeted by Hitler, trans people were. A pioneering research institute and clinic, the Institute of Sexology, was destroyed. These were some of the first books burned. Transgender people were forced to detransition. They were tortured, jailed, and disappeared. Fascism begins with othering and allowing hate to grow against a group, shredding their rights and due process. If you're not seeing it in our country right now, you're not paying attention. Today, it is the bathroom. Tomorrow, it will be the restaurant, the hotel, the job. And that's what it was before we passed the non-discrimination bill. We listened to stories of people and how they had been harassed and others. One woman particularly sits with me. She was in a restaurant having her lunch when the waiter came up and said, "Excuse me, we're going to package that to go. You're making that couple uncomfortable." It will not stop with trans people. Trump and his ilk are already dismantling the Civil Rights Act. Did you know that he has quietly ordered that segregated bathrooms are no longer explicitly banned?
What does that have to do with this bill, ma'am?
Because this bill is part of a bigger problem. Civil rights, due process for immigrants, it's another horror story. It's all related. Othering, fear, hate, fascism. Many of us haven't learned our lesson. Hopefully, many more will stand up. The famous Martin Niemöller poem is being written, rewritten. First, they came for the
Brenda,
trans...
your time is up.
All right, I'd like to just finish. First, they came for the transgender people, and I stood up because I'm cis and I'm white, and I know how the poem ends.
Thank you very much. Next, I'm going to call on Betsy Harrington, please.
Hi, my name is Betsy Harrington. I'm from Deering. I appreciate you allowing me to speak today. In high school, I played field hockey, and my freshman year, there was one boy on the Westfield team that started playing against us. And it was aggressive to play against this one boy, but the next year there was 5, and it was on the Northampton team. And of course, they won the championships, a bunch of girls got hurt, and at the end of that season, we changed the law, this was in Massachusetts, to not have boys in girls sports for a really good reason. We proved it in our experience. So that's why I'm here. I'm not here to negate anyone or tell them that you don't deserve a space or you should be disappeared or anything. I want people to be included. But there's a boys team and a girls team. There's a boys bathroom and a girls bathroom. We've designated it like that always for this very reason, to protect us. So when we talk about getting off of, you know, what a boy or a girl is, it's insanity is what I hear. Like, we all know, I know you all know what it is to be a man or a woman, the difference. When I use the bathroom, I actually use a period cup. It's actually something that holds blood that I now have to leave my stall, go out and wash out, and then go back into the stall and put back in. That is not something that I wish to share with anyone. Anyone who would never have that experience has no right in seeing it. So I'm sorry, there are reasons to keep the bathroom completely biological women and biological men. Some of us sit, some of us stand. The bathrooms were made differently for that reason. I think y'all are insane to go off of this very basic understanding of male and female. So please support this bill.
Questions for this witness? Representative Horrigan.
You're talking about the field hockey. Was there high school male boys field hockey in Massachusetts at the time? I'm pretty sure there wasn't. And regardless, so were there boys field hockey teams for the players to play on or not, or were they?
At the time, there was not, and they still had other teams to play on. There were teams that, like football isn't a girls' sport, so I'm not sure I understand your question.
All right, other questions? Representative Perez.
Are you aware that in ice hockey, they separate the boys and the girls at age 13 because at age 13, they're allowed to check, and therefore because of the difference in strength and size of the 13-year-old boys, it's harmful for girls to be playing?
I am aware. I actually tried out for the Olympics in women's hockey. I played boys hockey my entire life. And after that law changed that said there would be no more co-ed sports at all. So actually, I lost my ability to play boys ice hockey, and I had already made the varsity team. I was the first girl to play Division I ice hockey in Massachusetts ever. And I ended up suing the state and winning, and so I did play, and I did get that chance to try out for the Olympics. So yes, I understand.
All right, other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Beth Scare or Sayre. I'm not sure.
Beth Scare.
Scare.
And before I start my testimony, I'm sorry that Representative Wade left, because I wanted to let him know that I was in the restroom with him here at the State House, and I was uncomfortable. And the reason I didn't say anything is because I wasn't sure how he would respond. Women often won't speak up because we are wired to avoid conflict. So my name's Beth Scare. I'm a grandmother from Nashua, and I'm here supporting SB 268. And I'm wearing my suffragette sash to remind everyone that this bill protects women's rights. It protects our rights to safety and privacy. You will hear the opponents of this bill insist that it's not safe for trans-identified males to use men's restrooms in locker rooms or be in men's prisons. And why aren't men's spaces safe? Because men are in there. Have trans rights activists ever stopped to think by insisting that women's spaces be open to trans-identified males if they have made these formerly safe spaces into dangerous spaces? An estimated 91% of victims of rape and sexual assault are female, and nearly 99% of perpetrators are male. A large percentage of trans-identifying males are sexually attracted to women, and they transition because they have a sexual fetish called autogynephilia. Should men with autogynephilia be given access to women's and girls' spaces of intimate privacy or women's prisons? Many people who support allowing men in women's spaces scream and holler when you tell them that women and girls are being exposed to naked men in their spaces, and those men are watching women and girls undress. They insist it isn't happening. They can't deal with the truth that the system of protecting women and girls has broken down. It needs to be fixed, and this bill will help fix it. Let Planet Fitness choose to allow men into their women's locker rooms. Women can choose whether or not to join that gym and risk seeing a man undressing or a man watching them undress, or they can join a gym that respects their privacy and safety. And if you hear anyone today insisting that trans-identified males are in danger if they are placed in men's prisons, they don't know what they're talking about. Trans-identified males are put in men's prisons in New Hampshire, and we need to keep it that way. Women in prison do not deserve to be locked up with criminal males. If you respect women and girls and you don't want them left vulnerable, please vote ought to pass on SB 268.
Questions for this witness? Seeing none, thank you very much, ma'am. Next, Sarah Terrell, please.
Yes, she had to leave. We did pass around her written testimony is going around the table.
Okay,
so,
yeah, I've got that. All right.
So, she
all right.
had a hard stop at 12:15, and so that was,
all right.
we're past that time. So.
Next, Stephen Scar. Have I got that right? From Nashua? Ah, okay.
Stephen Scare, Nashua. Thank you for this opportunity to speak, Chairman and distinguished committee members. I urge you to support this bill so that the state no longer coerces girls to ignore the evidence of their eyes and ears. It takes unrelenting coercion to make people pretend that a man is a woman. Since 2018, the state has demanded that girls acknowledge males' gender identities and ignore the physical reality of the human body. But gender identities are entirely imaginary, based on people's desire to escape their bodies, fantasies about being the opposite sex, sex-based stereotypes, and circular reasoning. For example, New Hampshire law defines gender identity as a person's, quote, gender-related identity, appearance, or behavior. So by law, a gender identity is a gender identity, and a woman is someone who tries to look, act, and sound like a woman. Activists and legislators also coerce girls with threats of genital inspections and emotional blackmails. They tell girls that boys will die by their own hands unless the state forces them to share their locker rooms. The truth is that men can't be women. Men who say that they are women are men. Men shouldn't be allowed to play women's sports or share their private spaces because they're men. We have entered into the darkness that we were warned about 3/4 of a century ago, where the very concept of objective truth is fading out of this world, and the restatement of the obvious is the first duty of intelligent men and women. Please vote ought to pass.
All right, questions for this witness? Representative Horrigan.
I hesitate to ask this, but who was it who said that 75 years ago, sometime around 1950, which would have been certainly
George Orwell.
Who?
George Orwell.
George. Oh, okay. Yeah. Thanks.
All right, other questions for this witness? Seeing none, thank you very much, sir. Next, I'm going to call on Evelyn Ullman, please.
George Orwell. Yes. Okay. All right. I get it.
I'm here to state the obvious, so it should go pretty quick. I'm Evelyn Ullman. I'm Democrats for an Informed Approach to Gender. We're a 501c3 nonprofit. We represent Democratic voters nationwide, including here in New Hampshire. We strongly support SB 268 in the interest of ensuring fair opportunities and safe spaces for women and girls. The differences between the sexes is both obvious and consequential. Strength and size differences, along with reproductive physiology, have a tremendous impact on safety. Differing reproductive roles and longstanding cultural bias has detrimentally affected the trajectory of women in the workplace and in society in general. These differences are not dependent on an amorphous concept of identity, but rather they're based on immutable biological reality. Defining women based on anything other than a biological understanding of sex renders the category incomprehensible, and therefore the laws to protect women's rights are rendered incoherent. Women's achievements become anyone's achievements. Women's spaces become anyone's spaces, and women's burdens can no longer be understood as unique to females. Female is not an opt-in category open to men based on their feelings. It's based on biological fact. This reality must guide legislation in order to preserve women's hard-won gains. Democrats have long defended women's rights, and they should continue to do that by supporting SB 268. Thank you.
Questions for this witness? Yes, Representative Smith.
Thank you for taking the time to be here. Could you just help me understand one thing? You're here representing a 501c3 and lobbying for a specific bill, not here just to educate us on the bill.
So I'm here speaking on behalf of our organization, yes, to educate you about the bill and tell you what our opinion is on it, yes.
Thank you.
Yes, Representative Peternell.
Yes, thank you. And thank you, Mr. Chairman, and thank you for taking my question. Earlier today, there was a witness who said that this bill would open up a Pandora's box. Is it possible that the Pandora's box has been already opened and that this bill is putting a lid on the box?
I would say so because we haven't encountered these issues in years past when everybody just agreed on what a man and a woman was and we respected each other's spaces and boundaries.
All right, other questions for this witness? Representative Horgan.
I apologize. I didn't quite get your name or the name of the NGO you're representing. So
Evelyn Ullman.
Evelyn Ullman?
Democrats for an Informed Approach to Gender.
Okay, Evelyn Ullman, like the Ullman brothers.
Ullman with a U.
Oh, okay, thanks.
All right, other questions for this witness? Seeing none, thank you very much, ma'am.
Thank you.
Next, I'm going to call on Ty Thompson, please. Ty Thompson. Okay, I'm sorry.
I think they had to leave.
I think he had to leave. Yes. Sorry. Next. Sorry. Isabella Peters, please.
Hello, my name is Isabella Peters, and I'm here in support of SB 268 on behalf of Cornerstone. I'm also here on behalf of myself as a Granite State woman. I couldn't afford my private women's only gym anymore, so I joined an inexpensive public mixed sex gym. Sometimes there's a sign in the women's locker room that says, "Attention, male worker in the locker room." I appreciate that sign because it's rooted in common sense and courtesy towards women's privacy, which has been lost in this political debate on gender. I had the pleasure of meeting Riley Gaines last summer. She said in her book, Swimming Against the Current, quote, "We are being force-fed the message that women's rights, privacy, dignity, feelings, and safety do not matter," end quote. When it comes to sports, inclusivity for the minority is unfair for the majority. It's specifically unfair to women who are scientifically at a disadvantage. According to the National Institute of Health, from a study on biological sex and its relation to sports performance, quote, "Male subjects became notably stronger than female subjects at around 15 years of age. Greater male than female strength is not because of higher voluntary activity, but to greater muscle mass and type 2 fiber areas," end quote. Biological separation is warranted in sports. It's not just about dignity in competition, though. It's also about dignity in changing situations. Prisoners in New Hampshire have a constitutional right not to undress in front of a guard of the opposite sex. But Riley and a biological male were forced to change together. How come prisoners have more dignity than the women in our state? And how about schools? The Manchester School District, the largest school system in the state, allows access to restrooms, locker rooms, sports participation, and sex ed participation based on gender identity and not sex. We continuously get calls from parents about the chaos these policies cause, where, for example, a 12-year-old girl walked into a restroom to see a 17-year-old boy urinating with the stall open. That kind of offense under normal circumstances would put him on a sex offender list. But our houses of education aren't under normal circumstances, are they? Deferring on policy doesn't mean we hate the transgender community. As Christians, we are taught to love as Christ loves. But like Christ, we must also protect the innocent and protect the women of our society. This bill is simply a clarification of New Hampshire law. New Hampshire Chapter 354-A prohibits discrimination based on gender identity. But separating people by sex is not discrimination. Title IX has historically supported separation of sex for the safety and privacy of all parties, despite incorrect interpretations today. The state has the authority to separate people. The state has the responsibility to separate people. Women don't want their rights to safety, comfort, and privacy deferred to the affirmation of a small population. I'd like to close with a Cheyenne proverb that teaches, quote, "A nation is not..."
Time is up, so if you want to have something very brief you want to say, go ahead.
I'll just finish the quote. "A nation is not conquered until the hearts of its women are on the ground. Then it is done, no matter how brave its warriors, nor how strong their weapons." Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much. Next, Mia Engelbert, please.
Hello, my name is Mia Engelbert. I'm from Manchester, New Hampshire, and my question to this body is simple. As a transgender woman, which bathrooms and locker rooms am I supposed to use? If your answer is the men's rooms because I don't look or sound feminine enough for you, you are admitting that this policy is based on subjective criteria. Anyone can say anyone else doesn't look or sound feminine enough, and these subjective criteria are often rooted in Eurocentric standards of beauty. This is why cis women of color have their gender questioned more than cis white women do, as Alice Wade's story was basically about. If your answer is the men's rooms based upon the genitalia and/or genetics I was born with, your answer is based upon a middle school level of understanding of biology and a potential invasion of privacy. Neither is an acceptable approach to writing policy, especially policy that will affect some of the most vulnerable amongst us. And one representative earlier said, just look at your license. My license issued by this state says X. Where do I go? I would next ask how you intend to enforce these bills, but that's not the purpose now, is it? The purpose is to force transgender people into no-win situations. If we use the facilities that align with our assigned gender at birth, we are at a much greater risk of having violence enacted upon us, usually by men. If we use the facilities that align with our gender identity, we are running the risk of having violence enacted upon us by the state. Given these two possibilities, the rational choice for most transgender people will be to stay home, stay out of public life, and avoid these risks as much as possible, which is the real goal of these bills, even if every supporter of this bill is too cowardly to admit otherwise. I would be remiss to ignore my transgender siblings in detention facilities. They already have no choice but to exist around people who may well use violence against them simply for being who they are. Putting them in even more situations where they run that risk is monstrous. Prisoners are still human beings and deserve to serve their time without having violence brought to bear against them. This bill is terrible, hateful policy that exists for no other reason than to police gender and banish transgender people from public life. It should be tabled and never brought up again. Hopefully this body can find it within itself to do that. Thank you for your time.
Questions for this witness? Representative Peternow.
Thank you, Mr. Chairman, and thank you for taking my question. Can you please define gender for me?
I don't see how that's pertinent. Your bill doesn't seem to do that very well either.
All right, other questions? Thank you very much. Seeing none, thank you. Next, Audrey Hoist, please.
Thank you, Honorable Chair and esteemed members of the committee. Thank you for the opportunity to speak today. My name is Audrey Holst. I am a constituent from Nashua, and I am here to express my strong opposition to Senate Bill 268. I want to start with two stories. I'll try to keep this brief and keep my eye on the clock. The other day, I was at the gym, and I entered a locker room, and there was a trans woman in the locker room. And I got changed to work out, and she got changed to work out. And then I went and I lifted some weights, and she got in the treadmill, and then we went our separate ways. And that was my experience. I also want to share another story where I was in line at a conference at a women's bathroom. There's always lines at the women's bathroom, always. And I was in line. There was a woman behind me who I knew was trans from the conference. And we started talking. She had these like cool earrings on, so I complimented our earrings. And we went into the bathroom, and she used the bathroom, and I used the bathroom, and then we washed our hands. And she fixed up her makeup, and I fixed up my hair, and then we went on with our day. And my stories are really boring because it's actually just really boring. This is like a normal experience of sharing space with the trans folks. There's no drama and there's no threat. And if you don't have any like real life experience with trans folks and your only exposure is through stories, stories are really scary. And a lot of fear is created via story. And a lot of people don't share their boring stories because they're boring. If we all came up here and talked about our boring experiences with trans folks, it would be very boring. You'd all fall asleep because there's really nothing to talk about. The fact is there's 20 years of research found that there's no evidence that LGBTQ plus individuals, including trans people, pose a threat to others in public or private spaces. And the same can't be said for SB 268, which actually poses a tangible threat. I've cited my sources at the bottom of the testimony that we've passed out. I'm sorry it's not a clickable link on a physical page. But there is an increased risk of harassment and violence to trans folks. There's a negative impact on trans youth. There's actually a study published in Pediatrics found that trans girls had a 2.49 times higher risk of sexual assault when restroom and locker room access was restricted. There's a lack of evidence supporting unfair advantage in sports. There is already regulation about that and danger to incarcerated transgender individuals as well. So there's not any proof that transgender individuals pose any threat to me or any other members of the Granite State and beyond. And like I said, there's a lot of scary stories, and fear is taught. So if you've been
your
taught,
time is
yeah,
up.
thank
If
you so
wanna
much.
Finish up, please.
Yep, that's all I have to say, and I appreciate your time and your consideration.
Great. Questions for this witness, Representative Peternell and then Representative Smith.
Thank you, Mr. Chairman, and thank you for taking my question. I believe you said that you were in a restroom locker room and there was a trans woman who came in. How did you know?
Because we'd had interactions before, and she disclosed that information to me.
Thank you very much.
You're welcome.
Representative Smith.
Any statistics on how many cis gone into men's bathrooms, because there's always a long line.
You know, I don't know if this is going to get me in trouble, but I have gone into a men's room when the line has been really long and there's been nobody in the men's room. So yes. Yeah, thank you.
Other questions? Representative Horgan.
I'm sorry, I can't.
I went to a.
I think there may be something wrong with
Yeah.
something's wrong with your mic. There you go.
I went to a. Voting center she used, but she did instead of like using a private restroom, she apparently ran across the hallway to use one of the multi-stall restrooms that are provided there at the Grapponi Center, which certainly all of us in the legislature have been there, so you know. So would you believe that she just went and used one of the two restrooms provided, probably the ladies' room, so there was no fuss about that. But
If you say it, I believe it. Sure.
All right, next question.
I don't know if you do that. Okay.
All right. Yes, Representative Mannion.
Not a question, but so the microphones are like Christmas lights. If one goes out, they all go out. So if they're out, check the plugs in the back to make sure they're all the way in. That's it. When
My
you pull
apologies.
it, sometimes it pulls the plug out.
Yeah, it made a funny noise. I thought somebody was like drinking a soda, but then I realized
All right.
we're not supposed to do that.
Other questions for this witness? Seeing none, thank you very much, ma'am.
Thanks for your time.
Next, I'm going to call on Courtney Reed, please.
Hi, good afternoon, members of the Judiciary Committee. For the record, my name is Courtney Reed. I serve as policy advocate with the ACLU of New Hampshire, and we're speaking in opposition to this bill. To keep it really high level, we oppose this bill because it raises constitutional and statutory concerns regarding the rights of transgender people. But from a policy perspective, there are concerns that this bill would make transgender people unsafe and unwelcome in public life by permitting discrimination through a law that the New Hampshire governor had deemed unnecessary when it was vetoed last year. This bill would also undo meaningful bipartisan work done several years ago to make our state more inclusive and disregards longstanding federal anti-discrimination laws. And all of this begs the question, for what purpose? And I'd like to raise 2 points to that. Firstly, looking at the data, this bill really doesn't serve any safety purpose. There's data that shows when we have inclusive policies where transgender people can access the restroom that adheres to their gender, there are reductions in assault, and when there are policies that would mirror what SB 268 permits, there are actually increases in rates of assault and violence for folks using facilities. And again, the second point I'd like to raise that begs the question of what the purpose of this bill is, and that when you have a bill that permits sex classification, you have to meet that with a strict scrutiny review. And because of the data that I just talked about, the state's interest doesn't really meet the guidelines that are set out here. So I could go through the case law of where the courts have stood on this issue when we provided testimony on the House companion of this bill. I shared later with the committee some of the parts of the ruling from the Third Circuit regarding privacy concerns, and I'd be happy to reshare that with the committee after this hearing. But really, I think all of this begs the question of what the desired outcome of this bill is, because this blanket ban that it permits really doesn't satisfy any interest for anyone, whether that be promoting safety in the Granite State. Yeah, I'll just stop there to keep things concise. Happy to take
Questions for this witness? Seeing none, thank you very much.
Thank you.
Next, Louise Spencer, please.
Hi, thank you, Mr. Chair, for taking my testimony. Thank you to the committee. My name is Louise Spencer. I'm from Concord, New Hampshire. And I just find it ironic that this bill is called, the chapter is entitled The Law Against Discrimination, because this bill is about carving out the ability to discriminate against people. And I don't think there's any denying that that's what this bill does. And the harm this bill does goes way beyond the specific language of the bill, because what it does is it others people and it forces them to deny the reality of who they are. My father was a gay man at a time when it was completely unacceptable to be a gay man. It was considered a psychiatric disorder. And so he married, he had 5 children, he went to psychiatrists, he tried everything he could to conform to society's opinions at the time. I can tell you that because he was unable to live his truth, it caused the most damage to him. He suffered tremendously, and I can say there were other consequences to me as a child of seeing my father suffer greatly. And I'm so glad that today young people can be out and proud, and that society has changed those very terrible views that caused my father to be disowned by his family, to lose jobs. It was a terrible thing. It really, really was. And that's one of the reasons I show up on behalf of folks who are just trying to live their truth and their lives. And, I was shocked when there was a story about the elevators and a woman being concerned to get in an elevator because there were men in the elevator. According to the logic of this bill, that would support the idea of segregating elevators by sex. If you follow the logic of this bill, it will be a Pandora's box. It is not putting the top on the box, it is opening it. So, I also wonder about the 10-year-old transgender child who's afraid to go into a bathroom. No one should be afraid to go into a bathroom for any reason. And if there's a reason to fear using a bathroom, that's the issue we need to address. That's the core issue. So thank you very much.
Thank you very much. Questions for this witness? Seeing none, thank you.
Thank you.
Next, Nancy Biederman, please.
Good morning. Nancy Biederman, New Boston. Just about over a year ago, I was in front of my school board trying to get a male child to be in a safe space in the boys' bathroom. He was 10 years old. He did not feel safe because the school had been allowing a girl who thought she was a boy to use the boys' bathroom. All you boys here know what's in a boys' bathroom, and they do have to get somewhat unclothed to use some of the facilities in a boys' bathroom. This boy saw the girl in the bathroom, ran out, went to his parents, told them what happened. The school, to this day, has never issued an apology or given them any empathy or anything about how their biological boy son felt about his situation in the bathroom. There were other boys that were also not using the bathroom, or they would open the door very quickly, very slowly, and say, oh my goodness, is she in there, is she not? And decide whether they were going to use the bathroom that day. There were no accommodations, nothing given to these biological boys if they felt uncomfortable in that situation. I'm also here to testify because we also have a situation in the middle school in where the girls are currently being, that they're allowing a boy into the girls' room. This is from a student at Ware Middle School. I'm a student from WMS, and I am currently friends with this boy. I do not think it is appropriate whatsoever and is doing more harm than good. It makes students feel uncomfortable in the bathroom and is now starting to influence the other boys into pretending to be trans just to use the opposing bathroom. This is not okay in any means, and I'm sorry for anyone that has felt so uncomfortable to the point that they feel they can't speak up. As far as any of the students feeling like they can speak up, it's not the child that is trans or pretending to be another gender. That's not the person who has the power. It's the school district that has the power. It's the administrators and the teachers. They have the power. They are sexually harassing those students. Now, when we went to the school board and I asked for the bathrooms to be designated biological sex only, as they had always been, even when my children went there, they said they couldn't because of the non-discrimination law. I said this law needs to be clarified so they have direction in the schools to protect these children. And for those of you that say that little kids don't sexually assault other little kids, they do. We had a situation in our school on the bus. It's not just the bathrooms. I also want to let you know the Department of Health and Human Services will be taking out gender dysphoria as a disability under the school's 504 plans that was announced today. There is also a Supreme Court case, Ames versus Ohio Department of Youth Services. It is deciding whether a protected class, whether it's a major...
I'm sorry, your time is up.
Okay, whether a protected class, if it's a majority or a minority, do they have to meet the same levels of discrimination?
All right. Thank you. Questions for this witness? Representative Tripp.
Thank you.
Thank you. Thank you for taking my question. I'm interested that you said the school board said that they can't not allow trans into the girls' bathroom because of a rule. Do you know who set that rule and where it can be found?
That's the New Hampshire non-discrimination law that has, since Governor Sununu enacted in 2017, I believe, that included gender identity into the non-discrimination law. And they went so far as to seek out legal counsel because they were also concerned. But again, there still was no accommodations made for the child who did not feel safe to go into the bathroom. They did say that he could possibly try to get hold of an administrator when he had to use the bathroom so they could get him to another bathroom. But again, nothing was made for the biological sex for those boys that felt uncomfortable. And they were pretty much told to sit down and shut up and, just deal with it.
All right. Other questions for this witness? Seeing none, thank you. Next, I'm going to call on Anne Marie Banfield, please.
Good afternoon. Checking that time. Anne Marie Banfield. I am a parental rights advocate in New Hampshire focused on education. I've been doing this for 20 years, so I've got a long history. The first call I ever received on this was from a mother whose son had gone into a restroom with a little girl in the restroom. That's the very first call. This was years ago, and how upset he was. And so this doesn't just impact girls. And quite frankly, if you added boys to this, I would be good with that. I think that probably would be a good idea. One thing that this does too is it women, a lot of women and girls have natural modesty, and what you're basically doing is you're saying, go in there and ignore that voice in your head, ignore those feelings of modesty. And sooner or later, my concern, and this has been even verified by law enforcement officers, is that women tend to ignore those voices then. They tend to ignore those danger signs. And law enforcement will say a lot of women who are assaulted, a lot of times it is because they have been ignoring those voices in their own head. Women are not going away, and we're not going to be silenced on this. We have fought for too long. And in Kearsarge, for instance, where I've worked with the parents, it was reported to me that the girls were told, sit down and shut up about this. Too bad that you're uncomfortable. Too bad that you don't like the biological male undressing in the locker room. Well, guess what? We're not going away, and we're not going to shut up. There are two sides to this issue, but the solution is not to go after women and girls. That's not the solution. There have been assaults by transgenders in the bathrooms. Wyoming, Oklahoma, Virginia, you can find them. I can provide them if you can't find them. Parents have been ignored by school administrators because they're looking for guidance from the legislature. They look at that non-discrimination policy and they say, we can't do anything, we can't make these decisions. So this is a solution to that problem. I've accompanied young girls to school board meetings where they have said, if a biological boy enters the bathroom, we're going to hold it. We're not going to go. This is what these kids do. They hold it all day. They're not going into the bathroom. That's the consequence from this. I think Representative Manos asked a question about the differences. Would this be different in different schools? There's already a difference in schools on the transgender policy. It's JBAB.
Ma'am, your time really is up.
Okay.
Okay. All right. Questions? Representative Perez and then Representative Horgan.
Thank you. Thanks for taking my question. We always hear them say that we're discriminating against the transgenders. Do you feel that in circumstances like the bathrooms and sports and locker rooms, the people being discriminated against are the women in those bathrooms, sports places?
Absolutely. I mean, we fought for Title IX. I mean, that's the perfect example of getting equal treatment for girls to win awards and scholarships. And now we can clearly see that biological boys are taking those awards and scholarships away from them. I do understand that there's two sides to this. I do understand that there is another side. And I'm not saying that other side goes ignored. You find solutions. We look for solutions. But the solution is not to put women back in the 1950s. The solution is not to invade our private spaces. That's all we're saying.
All right.
This is not the solution.
Representative Horgan, you had a question.
Well, this bill doesn't directly address schools of any type, but does this problem that you're talking about, does this exist only in conventional public schools or private school districts, or does it happen in charter schools, private schools, and especially private schools that are subsidized by the EFA or school voucher program?
I'm not quite sure. Are you saying that if this bill is passed, would it impact those schools? Is that what you're saying?
Yes, or just, so then this problem only need to be addressed in regular public schools or other types of schools?
From what I read, it gives these schools opportunities. So in New Boston, when they use the excuse that they can't do anything, when the parents flooded the school board meeting, because I was at those school board meetings too, and saying we need to do something, and the superintendent saying, oh, we can't do anything, our hands are tied. We need you guys to basically tell us what to do. Now, in this bill, obviously, they would have a choice. But again, the JBAB policy, the transgender policy in all of our schools, some schools have it, some schools don't. Some schools who have it will have different wording from another school. So there are differences in how they've implemented the JBAB transgender policy in the schools. So from what I've read and from what this says is it's up to those individual school districts. So it could be a different decision based on what school you're talking about or what organization you're talking about.
All right, other questions? Yes, Representative Tur.
Yeah, thank you, Mr. Chair, and thanks for taking the question. I don't know if you're familiar with a fairly famous case, a trans boy named Mac Beggs in Texas, who, under a policy that I see is very similar to this, was told to wrestle on the girls' team, even though he was undergoing transition and had male musculature and other characteristics. He went on to become the statewide girls champion wrestler in his division 2 years in a row because of that. Do you see anything in the way this bill is constructed that, or first, do you feel that that was the right outcome? And second, do you see anything in this bill that would not allow something like that to happen here in New Hampshire?
I'm not familiar with that case, so I was having difficulty following. Is this a biological boy that was playing on the girl?
Yeah, sorry, let me clarify.
Yeah, I'm sorry about that.
This was a young person who was ostensibly born female, and who had been undergoing transition
to become a male,
being treated at least with the hormone part of that process, to the point that they now had male characteristics, secondary sexual characteristics, including musculature and some facial hair, and wanted to wrestle on the boys' team, but was told because they were born ostensibly female, they had to wrestle on the girls' team. And as I read this, I think that's also possible and permissible under this. I was wondering what your thought was.
So I would assume the same thing, that how that played out would also play out if this, but again, this is giving them the choice. It doesn't sound like this is mandated in terms of you can mandate that in your school, but you don't have to mandate that in your school. So then it becomes more of a local issue. Then it gives the administrators the ability to make that decision, maybe based on what parents want, like in New Boston, what the parents were saying. They make the decision and they don't blame you guys, because let me tell you something, they were blaming you guys for the situation they're in.
Just one quick follow-up.
Sure.
If I may.
Yeah.
Sorry. Lost my train. In that scenario, could you foresee a reason why one school district might make that exact choice in terms of their odds on prevailing in a sports competition, say statewide?
The same choice as yes, and yeah.
All right. Right, Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. You kind of piqued my interest when you said that some of the schools have adopted the JFAB policy. I suspect that this is something that probably the New Hampshire School Board Association is promulgating.
Yes.
Is this something that has been adopted by all schools, some schools?
So many years ago, and I don't remember the exact year, it was actually pre-COVID, the New Hampshire School Boards Association came out with the model policy, JBAB, so it's JBAB. You can look at in your policy in your school district to see if you have it. They came out with that policy. From that day, I opposed it because, first of all, it said keep secrets from your parents, that, you know, there was all kinds of issues in there. Again, use the bathroom that you identify with. They came out with that policy. Now, just a few years ago, they withdrew that policy as a recommendation, but many schools still have it. Some schools do not have it. Bedford doesn't have it, if I'm not mistaken. Some schools have taken it and, molded it to what they wanted for their particular school. The biggest concern I had with JBAB coming out was that there were no laws backing the actual policy. So the provision where it said that a student can use the restroom of their choice, or that school personnel was to withhold information if a child comes into school and uses a different name, there was no legal backing for that. There was nothing in state law. There was nothing in federal law that mandated that JBAB be instituted. So some schools adopted it, some did not. I question whether that was even a policy that schools should be enacting, because my understanding is we are a Dillon's Rule state, and that policy should be based on state or federal laws, but there were no state or federal laws to back up a lot of the language in that policy. So right now, currently, some schools have withdrawn it. If I recall, some of them have.
All right. Other questions for this witness? Seeing none, thank you very much.
Thank you.
So it is now 1 o'clock, and I'm going to recess the hearing on House Bill 268 so that a subcommittee on, I'm sorry, Senate Bill 268. I'm going to recess the hearing on that until probably about 1:40, maybe 1:45, so that the subcommittee on Senate Bill 148 can begin its work. And the rest of us who are not on that subcommittee can get some lunch. All right. And those of you, I know that we still have a number of witnesses on 268. We'll get started and pick up where we left off at around 1:40 or so. All right. Thank you.
You taking notes there.
All right, I'm going to ask that if you are not on the subcommittee on SB 148 or you're not listening to that, you please vacate the room as soon as possible. Please, we have a limited amount of time on this. Get out. Ooh. All right, I would like to open up the subcommittee on SB 148, and for the record, I am allowing these subcommittee members to eat today. I am a very benevolent chair, so you're welcome. Okay. All right, so we have a limited amount of time on this. I think that I got some feedback from the Attorney General's office regarding some of their issues with SB 148 as drafted, specifically the Senior Assistant Attorney General, Benjamin Agati, Chief of the Homicide Unit. There's really 4 issue areas that I'd like to address. I think that would clean up some of the language on this bill. Specifically, I can just go through the 4. Maybe we can go one by one, whatever works for you. Specifically, cleaning up the lines on the phrase felonious and intentional killing. That's page 1, lines 16 through 20, and page 2, lines 15, 23 through 23, and line 27. I've gotten some feedback from Attorney Lehman from the Senate Counsel's office, and they indicated that some language that might work for them is adding on these lines, feloniously, intentionally, or recklessly killing. So that would apply. That would clean up the language in saying, like, if somebody was driving a car and the car crashed, they could still collect from that estate if the person they were driving passed away. I agree with that, but I'd like to know what the committee thinks. I do think, in speaking with the sponsor of the bill, that she would like to keep the language of first-degree murder, second-degree murder. Let me see. Capital murder, first-degree murder, second-degree murder.
Not quite, but close. Can I go?
Yeah, go ahead.
Dive in? Because I've also prepared an amendment that does 2 specific things, and in doing so, takes care of 3 of the 4 of the Assistant Attorney General's issues. So, to mention, and one we're just going to have to make a decision on because there's 3 different levels of what crimes are we covering. My amendment covers murder in the first degree. Yeah, murder in the first degree. Okay, does not include second degree murder. The bill as we got it includes half of second degree murder. It does not include the reckless or negligent. The expansion that got sent over by this attorney from the Senate wants to expand it to cover more areas of law. For those of us who don't like the bill to start with a whole lot, expanding it even further to say that you can't write a newspaper article for profit or anything because you got into something that happened by negligence just takes it a whole big step further. However, let's put that aside for the moment because that's something we'll have to just decide as a policy thing if we, where we're going to come out on. The other huge area was this area about private citizens being able to bring an action, and it got very, very complicated because. In the probate court? Are you talking about in the probate court? Yeah, in the probate court, and the weird standard that the probate court had, and then whether proceedings, and this was like forfeiture, whether proceedings in the probate court could be used to extract information for the defendant, putative defendant, if he or she wanted to defend themselves. Anything they say could be used in a subsequent prosecution. On the flip side, the person accused, so to speak, in the probate court might demand the entire investigative file to show that he or she was innocent. So it caused both problems on both ends. And then they had this weird word, the provisional, whatever, other potential remedies, whatever it was, that the AG complained about. So I took that whole section out. And it took care of both.
What section was that?
It's where's the original?
This is the original.
It's the section 50714, the right. No, that's not it. Sorry. That's after conviction, they can do whatever they want. Yeah. No, it's the section here. In the absence of such conviction, the court, upon petition of interested, shall determine whether under the preponderance of the evidence be found criminal liable. If the court determines that, then you can go grab his money, irrespective of whatever happens or doesn't happen in criminal court. And then they had some other phraseology of provisional remedies, and that's not in there.
Okay.
So
could you be specific, Paul?
do you have the actual amendment that I sent you? If not, I have an extra copy.
No, yeah, if you have an extra copy.
Or extra several copies.
So, where are you talking about?
Well, since it's not in the amendment, it's not in.
Oh.
But, so if you want to take a look at go through the amendment part.
Yep.
It's added under definition, murder shall be murder in the first degree under 631A. Okay?
That's something we have to
Agree on.
agree.
Right.
Or disagree?
All the rest of page 1 stays the same. And all the rest stays the same other than what I've taken out, so it doesn't appear in here.
What about the whole thing about the probate court?
I've taken it out.
Okay.
So if you look at the original bill, that's on page 2, 562A6. So 562A6 no longer appears.
Okay.
So the standard would be felonious and
No, we've taken the words felonious and intentional.
And it's just
and
murders
all
in the
that.
first degree?
Yeah, because that's already defined in the statute, what murder in the first degree is.
Okay.
So it just refers back to that. Yeah, and they have like 3 or 4 kinds of things.
What are those?
Do you I don't know if I printed out that or all right, you have to go on your little machine to RSA 630:1-A.
What would take out manslaughter and
In second degree.
reckless?
630:1A.
Colon
So
1
he-
hyphen A.
1-A.
It should be murder in the first degree.
Yep. Purposely causes death, knowingly causes death. Felonious sexual assault,
Causing death by?
causing death. Yep. After, before, or while engaged in commission of or attempted committing robbery.
It's like felony.
Yep.
Murder.
Felony robbery.
Felony murder.
Murdering the president. Okay. Premeditated, deliberate. So
So it covers the intentional and felonious. But it also has what's generally called malice aforethought, or done with a bad heart, or
Yeah.
evil intention. What the original does, it just says intentionally and feloniously. I'll tell you what I was more worried about is you've got an elderly couple and they do a murder-suicide thing where, the guy offs his wife and attempts to kill himself and it's not successful. You know, that's not first degree murder, but can be, it's intentional and felonious. Granted, they're not necessarily prosecuted, but I don't want that covered.
Well, I don't know how you want to do this, but my big concern is the whole probate. Essentially, you're creating a whole fictional process to claw back. And I just don't like that at all.
So I guess what we're trying to do though is the purpose of the bill is to make sure that somebody committed to these things cannot profit from this in probate.
Right.
So how do we create the separation of if there's a suit in probate and it's happening at the same time, do we wait until probate has to happen after? Is that what you wanted to say?
Yeah, basically
Like
what,
after a final
Yeah.
conviction?
Yeah.
that's what the other section of this already says. After there's a conviction for the appropriate level of crime, victim
And
can
an
go
appeal.
sue for false profits rottenly obtained. That's all clear. The problem with the probate one is that I'm a prosecutor. You missed Tom Bilardi because he's about the most right-wing prosecutor in the state. Oops.
You're on the
Sorry.
public.
We'll take that. Let's strike that. Is that, and I raised this in a question at the hearing, if a prosecutor doesn't have enough of a case to bring, he or she can wait, encourage the victim perhaps to go into probate court and give the suspect a dilemma. If they contest it in that court, the prosecutor then can use whatever that person says perhaps to make the rest of the case. That's not what this should be about.
No.
And otherwise, if I'm in that court, probate court, and I want to show, hey, I didn't do it, and I've never been charged, I want to see the prosecutor's file, Department of Justice file, and to be able to show that why a judge should not find that I. So we get rid of the preponderance evidence. We get rid of all those problems by taking this section out.
So, but so what Lehman sent me was this 501I5.
Yeah,
And
I looked at that and I said, what does it actually do?
Well, it's keeping it's keeping it separate. So,
But how does it, in real life, how does it keep it separate is the question. So let me go through. I'm not trying to be, Mr. Expert here.
Tell me where you're reading.
This is a proposal that you probably haven't gotten yet.
I handed
Yeah, you didn't.
right here.
This one.
Oh, okay, I got it here.
Nothing in this chapter
Yeah.
shall be construed to limit this ability of the state of New Hampshire to take any action, or utilize any process to enforce the criminal laws of the state.
That's fine. That doesn't,
Yep.
what does it say? It just says
Right.
prosecutors can prosecute.
Which is fine. Yeah.
Yeah.
No decision of the probate court under this chapter shall be construed to have any preclusive effect on any criminal
Right, so
prosecution.
that's answering the question of if the probate judge finds, A, there's not even a preponderance of the evidence here to show Mr. Smith committed the crime. Mr. Smith might want to say to the prosecutors or to a jury, hey, we already had somebody look at it. What they're saying is that makes no difference. Prosecutor can still bring a prosecutorial case. I agree. There's nothing wrong with this. And it does answer the preclusive, question. But it doesn't solve any of the problems of going to the probate court. So it's a nice little addition. But it doesn't do anything about the flip side, the two problems that even the AG and in his testimony to the Senate said these are problems.
Okay, so if we strip out, so say I agree with you on the first degree murder. What other changes did you propose to make?
The only other change was to take out the probate stuff.
So the probate would happen after the
No,
conviction.
there would be no probate. It would be simply if I killed your wife and I am found guilty of killing your wife and I go write a book you would have the right to sue me civilly for the proceeds of that book, and that's in here.
But you don't want,
So why would probate court be involved?
well, because there's also the question of who gets the money after the person is murdered. So
What money? The money from the book or the
the
just
victim. Because don't you have to go
And-
through probate court for death of?
Right. So okay. So
I guess it
all right.
raises
So
the
this
question
is
of like if
inheriting through probate.
inherit. Yes.
Court. Inheriting through probate. Okay.
Give a real life example, because I'm not sure what.
All right. Because
I
that's
mean,
a fair point.
I mean,
I'm not
you and I
sure.
say you and I are married.
Mhm.
I kill
Right.
you.
Mhm.
There has to be a way to keep him from profiting.
That's
From
the
that
intent of
killing.
the bill is like, but
Right.
I'm the
From
person
the
that
estate.
benefits the estate.
So you now have $1 million. Did you publish this book?
No,
But
it's not even that.
Yeah,
it's like,
I was
it's
focused
like
too much
we're
on the-
husband and wife, and I'm the beneficiary of our estate,
Right.
and I'm convicted of killing you. I would still
Right.
get the money from that.
Okay, you're right.
That's what we want to address that point.
Well, I'm not sure. So we're married, we have a will. I leave everything to you, you leave everything to me. That's
Right.
how it would operate anyway, but you kill me, you write a tell-all book.
It's not even about the book. It's
Skip
just
up.
our estate.
It's just inheriting.
The
You
question,
and
the
Joe
question
are
we're
married.
raising is, should I be able to profit from the estate even after I was convicted of killing you?
I think that should be a separate bill.
But that is kind of what this bill is about.
That's what this bill is about too.
Yeah, I recognize that that's
I don't know the
It's fair.
probate law well enough to know whether the court already has the authority to say, sorry, you committed murder, you can't inherit this money.
assuming they do not.
Well, why
Because
not
there's no
answer
need.
the,
What?
why not answer the question? I mean,
Because we wouldn't
why,
have this bill, I think, if it's covering territory already covered.
And I don't know that answer either. So, all right. So say, okay.
We can get an answer to that.
I mean,
So
it's
say
the
we can get an
concept of
answer to
clean
that.
hands, right? You can't. Paul?
Listening, yeah.
Oh, okay. It's the concept of clean hands. You can't, right?
Right?
You can't profit. I'm trying to think of another example. Can't think of another example, but you can't do something untoward and then, you know, it's like, what's the old joke about killing somebody and then throwing,
Yeah, throwing yourself in the mercy of the court because you're
Right.
an orphan.
yeah, because you're an orphan. Yeah, I killed my mom and
It's a timing question for probate court. And I think you're right about
It would have to be after
subsequent, you know,
a convicted of
Right.
of murder in the first degree.
degree
right.
cannot claim through probate court.
And you'd have to have a provision saying if you're the beneficiary of this, you must wait until after like the court before you can then go to probate court for what you're owed or what you're.
Well, let's just see how that would work. So you two are married. You've got $1 million estate. You kill Zoe. That's now in probate court. You haven't been charged with anything yet. So you're in probate court waiting to inherit or receive your $1 million. But that wouldn't work if you were eventually charged and convicted. So it's a timing problem. Is there a way to block the probate court from ending its proceedings, closing the estate and sending the checks out, so to speak, until after any criminal prosecution is done? Except in murder, you know, there's no statute of limitations.
Well, I feel like after there's one like decision, that should be enough, even though there is no statute of limitations, because you do want
What kind of decision? Decision by who?
decision by a court.
So do you want the criminal court to make it, or do you want the
No.
probate court to make it?
No,
And how
not
could,
the
the
criminal
problem we have here is that the probate court is trying to decide by its low standard, preponderance, 50% plus one, whether they have enough information that a jury could find somebody guilty beyond a reasonable doubt without having a whole criminal trial. And that's the problem with having it done before. If you wait till the person is convicted, or you set an arbitrary 5 years or whatever, then you can get around that. It's that kind of timing problem. How do you keep the probate court from giving the cash to you prior to a criminal court deciding whether you've got criminal liability or not?
Well, I think this would arise in a practical situation where if this occurred, the children or the brother, my brother, let's keep it simple and keep children out of it. My brother would file suit in the probate court and say, you can't inherit, I'm entitled to the money. So somebody would affirmatively have to file suit in the probate court to say, you can't have this money, or you're not entitled to this money under this proposed statute. It
What if there
isn't
are
that-
no brothers, sisters, other family members? Or what about if the Attorney General's office sends a notice to the probate court saying we're investigating Joe for potential criminal liability?
I think we're overcomplicating this. I think if we just say, like, the court the probate court shall not issue
A final order.
a final order until the criminal court has not exhausted, but like made a determination.
Yeah, the problem is how long how long do you have to wait
Right.
for a case that may
Meanwhile, our
never
kids
be
are
brought?
starving.
Case that may never be brought.
Right.
Meanwhile, our kids are starving or can't pay college tuition or whatever, because
Yeah.
you bumped me off and now it's all stuck in probate court.
Yeah. Okay.
What we don't have are, if one of the folks testified these laws exist in 47 other states, what have other states done, if anything, to deal with this issue? Because I've only seen the issue in Son of Sam cases in terms of books, which is an easier issue. This one is attempting to talk about distribution of marital or other property,
Right.
which is a far more complicated issue. And that's why they have this complicated probate thing, which is hideous beyond words.
All right, so I guess we have two options. We can go with the Birch approach and strip out all that probate stuff, but I do want to address it some way. So is there a way that maybe I can talk with an attorney or two and see if they have recommendations on something to add into it? Because I guess I'm okay to compromise on the first degree murder thing just to kind of get the ball rolling on this. But I want to see if there's a way that we can include some language about probate.
Yeah, I would want to know what currently happens.
Do you do probate work?
I've done some, but not enough to rely
So
on.
there's
my
nobody, and I
knowledge.
don't think Catherine does that.
I don't think so either.
So I think nobody.
Well, I can talk to an attorney, Senate attorney, somebody.
Yeah, but it's already got kind of his flavor a bit. But yeah, there's never any harm in doing it.
I can ask the probate and trust section of the Bar Association, see what they
That might
say.
be a useful
Yeah.
place to go.
So we want to refrain from violating 91A. So we can have another work session on this on like.
Next Wednesday. When are we exactly?
Well, we're supposed to be execing this next Wednesday, but there's no rush.
No, it's not.
This is not an early bill.
Yeah. Yeah, we could just ask Bob not to.
He would have to
Exec
drag
it.
us back for an exec for one bill, but
So
we
be
could
it.
do that at lunch on a session day or something like that.
Right.
Yeah. So why don't you do that, and I'll go get some information.
Do you
from
think you
people I know.
can sell this to your caucus?
Yeah.
Okay. All right, because I just want to make sure we're not spending all this time.
No, you know what, I'm okay. I'm okay with the first, I would like more. But I do want to address what the sponsor intended with the probate stuff too, and add that in there. So I think I could.
I think maybe there could be a provision that says,
I think
see, there wouldn't have to be
I
a,
think that the probate court is a court of equity.
yeah,
Why couldn't it currently say, sorry, you can't profit from this?
because it hasn't been determined whether the person should be barred from profiting or not. No charges have been brought.
Well, we're gonna have that problem. And as I
Only
said,
after conviction, you don't have that problem.
right, but the starving children can't pay college tuition is gonna be a real problem also, because the person who's entitled to inherit is entitled to inherit.
Or may not be entitled to inherit, and if there's nobody, it would be the equivalent of dying intestate. If the only person designated can't do it, then you're going to go to the normal distribution
Right.
of children, blood relatives and the like.
Right.
But we could have a situation where you say that if at the beginning, if a homicide is determined, you may not know who to charge or whatever, but the coroner will give the finding pretty much right off the bat that it's been a homicide. So you can say that if there's a probate proceeding involving the estate involving a homicide, its proceedings shall be stayed pending either a criminal conviction or a representation by the Department of Justice that the spousal person
Beneficiaries, yeah.
is not a suspect.
There you go.
But still, somebody would have to file in the probate court and say, not you, murderous husband, it's going to me.
Well, not necessarily, because Joe can go in there and say, I like my distribution. And at that point,
But not all estates are probated.
well, there is that, but
Yeah.
I mean, typically the ones that there's
I mean, if
a
it's
finding
in
of
trust,
serious money, they are.
well, if it's in trust, it's not going to be probated. That's why a lot of people do trust.
yeah.
I don't know. So why don't we plan on huddling in our own corners and then pick this up Wednesday at 1:00 next Wednesday?
Let's just do next Wednesday, 1:00.
Yeah, let's just get
Because
Bob's
we have an
price.
exec at 10. Should be plenty of time, 10 to 12 or whatever, and then we can do this at maybe 1 to 2 next Wednesday or something like that. depending on-
Yeah, I'll reach out to the Bar Association. You'll check with some attorneys.
Yeah.
Um,
All right. Sounds good.
Right, I'm good.
We're adjourned.
And
Okay, I'm going to bring the judiciary hearing back to order and reopen the hearing on Senate Bill 268 and recognize Bronwyn Sims to speak. And just to remind everyone, there's a 3-minute limit on testimony. Thank you. Yep.
And there's also an sit down. Yeah, I will. Thank you. There's an amicus brief and my testimony that went around that I forget Rep Manis should have passed around.
Thank you.
Good afternoon, members of the House Judiciary Committee. My name is Bronwyn Sims, and I'm here to speak to you about Bill SB 268. As a woman, athlete, and gymnastics coach for girls and women in New Hampshire, I urge the state of New Hampshire to protect the rights of female athletes and all women to fair competition, safety, and privacy in high schools, middle schools, colleges, athletic training facilities, the YMCA, our prisons, jails, and other facilities. I belong to a group of coaches and athletes across the country who have signed an amicus brief, United States versus Skermetti, to the Supreme Court, representing girls and women and advocating for safety and fairness in their sports and related spaces. I'm the New Hampshire State Chapter Leader for the Walkaway Campaign, an independent grassroots organization that is dedicated to bringing Americans together to walk away from intolerance and societal discord and to walk towards unity and civility. I also serve as the Northern New Hampshire Chapter Leader for the Independent Women's Network. Independent Women's Network fights for women by expanding support for policy solutions that aren't just well-intended, but actually enhance freedom, opportunities, and well-being. Independent Women is also the author of the Stand With Women Act, which is the sex definition and preservation of female spaces model legislation that has been implemented across the country and most recently used as the basis for the president's executive order to define sex-based words. I'd like to thank New Hampshire legislators for their intention to protect women's rights, privacy, and safety, acknowledging the biological differences between men and women and the importance of single-sex spaces is supported by over 80% of the country. The amended version of SB 268 is a step in the right direction, particularly the amendment to define sex and biological sex as either male or female. I do, however, caution the inclusion of the language of gender identity in the bill. By including gender identity...
I apologize, that's your time.
Can I finish this statement, please, sir?
Well, you have a 3 minutes, so you can want to make a 1-sentence statement, that's it.
Okay, the bill opens the door to allowing men to enter women's spaces. For this reason, I must take a neutral position on the bill. I encourage the New Hampshire State House to further amend the bill by removing the language gender identity to truly protect single-sex spaces.
Thank you. Any questions? Seeing none, thank you.
Thank you very much.
Eleanor McDonough? From Exeter, Eleanor? Carolyn Pomini? Okay. Kelly Twiss? Is that right?
Hello, everyone. Thank you for allowing me to speak. I have a handout. Should I pass it out now or after?
You can wait. Yeah, you can wait till after if you want.
After? Okay.
Yeah.
All right. So I am here today from Kingston, and I would like to raise urgent concerns and submit notice that SB 268 poses a foreseeable and substantial risk of harm to transgender, non-binary, intersex, and gender non-conforming individuals, and exposes the state of New Hampshire to litigation. Senate Bill 268 gives legal cover to classify individuals by biological sex, yet it provides no definition, no enforcement, no standards, no notice requirements, and no guidance for implementations. Currently, New Hampshire doesn't have a law regarding this, and this just opens up the Pandora's box of all kinds of different questions because there's no guidance, there's no guidelines, it's too broad, there's way too ambiguous. For me, I'm just an individual, so when I read that, I have no idea, pretend I'm a business person. What does this mean I can do? How do I enforce this? Do I put a sign up? Do I put a sign up like this in the State House? Is this what you want to have in the State House? Is that what you want to have on the outside of a business? It's not privacy, it's not safety, it's hypocrisy. There's no documented threats. There are no recorded cases in New Hampshire of transgender individuals assaulting anyone in restrooms or locker rooms. This bill solves no problems and creates real harm. And keeping in mind, there's no law right now preventing any transgender person from going into the restroom or the locker room. There's nothing. There's no data. Nothing has happened. Senate Bill 268 is vague and unconstitutional. It violates due process, it violates the Equal Protection Clause, and it exposes the state to lawsuits. Even if aligned with current federal executive orders, those do not override civil rights laws. If this bill were enforced right here at the State House, everyone entering this building, including visitors and even your current or future colleagues, would be classified and required to use the restroom of their biological sex. Again, are you prepared to post a sign like this to confront them, to police their bathroom activity, to assign someone to monitor who goes in and out? If that sounds absurd, invasive, and discriminatory, it's because it is. You took an oath to faithfully and impartially discharge your duties according to the Constitution and laws of this state. Senate Bill 268 violates both. It is vague, it's discriminatory, it's legally indefensible. It does not solve a problem, it creates harm, it does not uphold the law.
I
it
apologize.
undermines
That's your
it.
time.
I urge you to decide based on your oath, not your personal ideologies, and I urge you to vote inexpedient to legislate.
Thank you. If you want to pass them in at either end, Dan, we'll bring it around. Appreciate it. Thank you. Alloway Testerman. Alloway Testerman. David Trumbull.
Thank you, Mr. Chairman and committee members. My name is David Trumbull. I'm from the town of Ware, and I oppose this bill. The law not only makes policy, it serves to educate. This bill starts off by saying that it recognizes the existing rights of transgender people to be treated with, quote, equal dignity and respect. But then it puts major hurdles and barriers to trans people from exercising these rights. I think the result of this bill will be to reduce public acceptance of trans people, especially given the language of the prime sponsor when he basically equated trans people as either being mentally ill or having evil intent. Looking for a legal analysis, the bill uses the compelling state interest test, which requires 3 steps. First, the weighing of the interests. Second, the law must be narrowly tailored to its end. And third, the law must be the least restrictive alternative. I think this bill fails in all three areas. Let's start at the back end because nobody's talked about it first, which is the mental health facilities. By New Hampshire law, if you're committed to the state hospital, you have a right to treatment. You also have a constitutional right to a safe conditions. Confining a transgender woman to a male ward in a male hospital would be the opposite of proper treatment. They want to go to the women's group. Being forced to be with men would be antithetical to their proper treatment. I would suggest it also would be unsafe for a trans woman to be on a men's ward. For sports, I think we should use the International Olympic Committee model. They are looking at three things: access, fair competition, and safety. Instead of a complete ban on trans girls competing in sports, a more practical alternative, a less restrictive alternative, would be to say that children who begin transitioning before puberty and take blocking or testosterone blockings for 12 months should be permitted to compete in the girls category. That comports with the science on this subject. The Canadian Centre for Ethics in the Sport did a literature review at the end of 2022 of 11 years worth of studies, and they concluded there is no firm basis available in evidence to indicate that trans women have a consistent and measurable overall performance benefit after 12 months of testosterone suppression. So in this case, you can accomplish both objectives. You can have competition fairness, and you can have access as well. For those who would be transitioning after puberty, I think it should be based on the science, which is what the International Olympic Committee is doing. As far as bathrooms, this bill has numerous problems. First, it interferes with people's First Amendment free speech and freedom of assembly rights. People who are transgender will not be able to safely go to public meetings at their school board, town meeting, court system, or the state house. It also discriminates against children in schools. Transgender children should have the right to use the bathroom of their choice and not have to not go to the bathroom for an entire day. A court case about this, it was called Grimm versus Gloucester County in Virginia, went all the way up to the Fourth Circuit Court.
I apologize. That's your time.
Oh, okay. Thank you, sir. So in that case, the judge said that it would be discriminatory against children to not let them use the bathroom of their choice. Thank you, sir.
If you have written testimony, I don't know if you want to turn that in.
You know what? How about, will the portal be open tonight?
Yeah, should be.
Okay. All right.
If not, you can
There was
email
a
it.
lot of discussion today. I just want to fix it up. I'll send you tonight
Thank you.
to the portal.
Mr. Chairman, before you call, well, you finished?
Yeah. Go ahead.
Before you call the next witness, we just were handed a very neat, detailed testimony, but it has no name on it. And I think I know who it came from, but we need to know. So could you please tell us that? Who was that? Kelly Twist.
It was Kelly Twist.
Yes. Thank you. Any questions of this witness? Representative Tripp?
In order to qualify, oh, thank you for letting me ask my question. And thank you for taking my question. So we've been talking about this for quite a while, and it seemed to me that something you said triggered a question I had. So how does one qualify being a transgender woman? Is it just a matter of waking up one day and saying, I'm a woman?
I'm not a trans person, but I have gotten to know quite a few people, and I've never heard anybody say they woke up one day and decided to be trans. I think it's something that comes from within a person, and that's just their true person. That's who they are.
Thank you.
You're welcome, sir.
Any other questions? Seeing none, thank you.
You're welcome.
Sarah Smith? Sarah Smith? Okay. Do you know if she left? Okay. Lynn Stanley?
Excuse me, my thanks to the committee for hearing my testimony today. For the record, my name is Lynn Courier Stanley. I am a social worker. I live in Pennacook, and I'm the executive director of the National Association of Social Workers, New Hampshire chapter. On behalf of our 875 members and the thousands of BSW, MSW, and DSW social workers in New Hampshire, I am here to ask you to please stop. Please stop with this legislation and all the other anti-trans bills that have been brought forward this session and in sessions past. You are hurting people. You are hurting people. 80% of the social workers provide 80% of the mental health services in this country. We know what we're talking about. You know what we're talking about too, because you have heard from hundreds and hundreds of children, their parents, adults, and professionals who have all told you how legislation like this hurts people. I hear from social workers constantly about the mental stress and toll that bills like this are having on their clients, regardless of whether they're LGBTQ plus or not. And even if you decide to discount the hundreds of hours of testimony that you have heard from New Hampshire citizens, we also know that this type of legislation is hurting women, because people have decided to take it upon themselves to become the arbiters of who is feminine enough to enter women's rooms. We have growing number of incidences of big-boned women, tall women, women with short hair, who are being confronted and assaulted for trying to enter a woman's room and not meeting that person's accepted level of femininity. People just need to urinate. They want to be able to urinate in the place where they feel comfortable. People who want to do bad things are not going to be deterred by a sign on a door. People do not deserve to be accosted or assaulted because they don't meet someone's level of femininity. This bill does not protect women. It harms women. Thank you for hearing my testimony, and I'm happy to answer any questions that you might have.
Question, Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question.
Thank you.
I asked the same question to the gentleman before you. As a social worker, you seem to be quite knowledgeable about transgender people. Is there a way for venting that people are transgender?
Oftentimes, the social worker is going, thank you for the question. The social worker is going to see an individual, whether they're a child or an adult, who is probably questioning or coming to work through whatever it is they need to work through as they are either contemplating, maybe I am, maybe I'm not, and whatever that process is going to be. Does that make sense? I want to make sure that I'm answering your question.
So you talk to them?
The social worker in their role will, yes.
Follow up, please.
Sure.
So that is primarily the vetting process that's used to determine that the individuals are transgender?
I think as far as a vetting process, I believe it's an individual process. It's something that somebody goes through, and they will go to their resources, their doctor, their PCP, their mental health provider, might be a social worker, and to talk through things. Maybe they're certain, maybe they're not, talking with their doctor about any medications or things that they might use in order to, if they want to do some sort of transition. But I think maybe what you're talking about is the vetting process, like with the Olympics, and that's certainly not my area of expertise at all. But it is a process, it is something that people go through, something that they know within themselves to be true. We all have things that we know within ourselves to be true. And sometimes it doesn't conform with what's on the outside. And sometimes they need help in either coming to terms with that, or how they're going to tell their family, or how they're going to navigate society. Those are all things that they might go to a social worker or other provider to help with.
Other questions? Yes, Representative Petterno.
Thank you, Mr. Chairman, and thank you for taking my question. I think you have me really, really confused now because I'm not quite sure how you're defining a woman in your testimony. Could you be a little more clear for me?
Thank you for the question. For the incidences of women who are being assaulted and confronted because they don't appear feminine enough, in all the cases that I have, they are women who were born with and currently possess a vagina.
Other questions? Seeing none, thank you.
Cisgendered women.
Oh, I'm sorry, Representative Tripp, did you have another question? Oh, all right, thank you. Thank you very much.
Thank you.
Next, Anthony Foote, please. Anthony Foote of Bow. All right, I don't see Mr. Foote here. All right. Lily Tang Williams, please. From where?
Excuse me, do you have a clock somewhere? I want to.
Oh, we have. We'll
let you know.
We'll let you know. Yeah.
Okay, I'm sorry. I can. Yeah. I'm Lily Tang Williams. I live in Ware, New Hampshire, and I was born and grew up in communist China. What is happening today in the West countries and in this country, I say that's very similar what I survived. It's all part of cultural Marxist identity politics. It's between oppressor and oppressed. So oppressors have their own subcategories, oppressed have their own. So we used to deal with in this country not long ago, it's about people of color and the critical race theory, DEI, they oppress the illegal migrants, and now it's a trans kids. I want to give you a unique perspective to create a genderless society. You cancel men first, which we did. If you disagree with leftist agenda, you are white, supremacist, racist, bigot, toxic man. You are canceled first. They are now erase the biological difference between man and a woman. And if you deny their biological sexual differences, you in fact erased woman. I'm a not hateful person. I love every human being, regardless of political beliefs. I just feel like it's my duty to warn people this happened before in the history. And the Simon here later can testify. He went to some trans young activists meetings, and those people are self-identified as a communist and Marxist and mixed with transgender activists as young people. It's very concerning to me. And also, I am a social worker with a master's degree, and be adolescent and search for self-identity is their major crisis for their life stage. It's normal. They do need the counselors, parents, communities help, but we should not pandering to a few people to push it down on that to the entire woman, gender, race. Woman cannot be canceled. I was canceled in a communist country. I could not talk like a woman. I was not called by girl, woman. I was called a comrade. Are the social justice warriors today also call each other by their name? I don't know. They need to study Red Guards, their very sad fate. So I'm asking you to stand for girls, to stand for men. I do offer solution like Thailand people do. Thailand country, they have lady boys. If you feel like dress like girls and you are man, biological man, you can play your own sports. You can go to some places. Everybody is very nice to you and very compassionate, but they call you lady boys. But do not use that infringe women's rights. And the woman's rights as a biological sex, as female, we have a right to exist, to have a privacy, to have our sports.
Ms. Williams,
My body,
you're
my
kind of-
choice. Remember that slogan.
All right.
And thank you.
Thank-
I'm happy to answer any questions.
Questions for this witness? Seeing none, thank you very much.
Thank you. Have a good day.
I'm going to call on Kathy Stratton, please.
Good afternoon. My name is Maura Weston. Kathy Stratton had to leave, and so I'm going to step in briefly in her shoes. As I said for the record, my name is Maura Weston, and I am representing the Medical Society here today. And Kathy is our CEO, and as I mentioned, she could not stay. Today we are speaking in opposition to Senate Bill 285 on behalf of our 2,000 physician and medical student members who live and treat patients here in the Granite State. The New Hampshire Medical Society's primary mission is to advocate for and promote public health issues that impact our patients. We believe that we are in opposition to Senate Bill 268 because we believe that trans rights and human rights are the same thing. To protect one is to protect all. We believe that this is an attempt to permit segregation, and it is sanctioned discrimination. We believe that the legislation in front of you is based in fear and is a slippery slope. We believe that there could be significant mental health consequences and implications from this. And just in closing, we believe that this creates a public health issue negatively impacting our patients. It is based in fear, discriminatory, and again, we do have concern for potential mental health consequences. With that, we recommend the bill inexpedient to legislate. Thank you.
Questions for this witness? Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. So the people that you represent, they provide medical services to transgender people?
Yes, I represent the New Hampshire Medical Society, and we do have member physicians who treat patients across the board.
Okay, follow up, please.
Yes.
So you must have some way of vetting that the people are transgender in order to provide these services, correctly?
First of all, I'm not a physician, and I don't know the process that goes on between our providers and our patients. And I think that that's a very sacred relationship, and I could not speak to what that process is. I think that the patient-provider relationship is unique to that relationship and sacred.
One more?
Yeah.
So
there is a process, it's just a secret.
I'm sorry I can't answer that question. I don't know what the process is that a provider engages in with their patient in a private conversation.
Other questions for this witness? Seeing none, thank you very much.
Thank you. I appreciate your time.
All right. Next, Sarah Terrell. I think I may have called that name before, but okay.
Yeah, she had to leave around 12,
All right.
12:15. We have a written testimony.
Okay. Catherine Renish, please. Remish.
Thank you for taking my testimony. I'm Catherine Remish. I'm from Hollis. I grew up in Bow. I went to Dartmouth. New Hampshire is my home. And I just wanted to clear something up before I begin my testimony. I think some people here might not think that trans women can have vaginas. Trans women can definitely have a vagina. I just want to make that clear. So if a trans woman with a vagina wants to go into the women's bathroom, is that not going to be okay? Rhetorical question. Anywho, I'm opposed to this bill. And people will speak and have spoken about science and morality also in opposition to this bill. But I'm going to tell you a story that will hopefully appeal to your emotions, your hearts. And to paraphrase a testimony that I heard in support of this bill today, and similar bills in the Senate session as well, a boy fifth grade, maybe middle school, elementary, walks into a school bathroom and discovers someone he had believed to be female in the boys' bathroom. He is uncomfortable and confused and has not encountered this before. It's new. He returns to class and refuses to use the bathroom for the rest of the day or any day going forward. This is terrible, okay? This is not right. Children should not be uncomfortable using the bathroom at school. But it's important to remember that those are the feelings, and this is the story of every trans child who was told they couldn't go into the bathroom that they felt was their bathroom. How do you choose between two kids? The boy in this story was told he could get permission to use a special bathroom, and this was upsetting to him and his parents. Totally, rightly so. No child should have to feel singled out. But trans children are often told they have to use a different bathroom, a special bathroom, the teacher's bathroom. We are parents. We all want our children to be happy. And so why can't we empathize with all kids? Why do we have to choose between them? The choice of choosing between them, that's the problem. All kids should be comfortable in these spaces, these intimate, private spaces. So let's look at this situation as a teachable moment. How do you resolve problems between kids? You sit them down and you talk it out. You teach them to show kindness to one another, acceptance. You have them tell each other about their experiences, about pronouns, what it means to be non-binary, gender expression, gender identity, what it means to be male just to one kid and female to another. Now that we've done this, the fifth grade boy knows that trans people exist and that they are good, normal people, and they do not have any malintent, malicious intent. He is no longer uncomfortable. He has learned that it is okay and that it is acceptable. Fear of this kind of thing is taught. It can also be taught to not be afraid. We can be taught to not be afraid of the dark. We can be taught not to be afraid of trans people if we were previously taught to be afraid of them. And when this boy encounters this situation again, as he will, because trans people exist, and they're everywhere, not a lot of them, but you will encounter them, he won't give it a second thought. Open
Ma'am, your
conversations solve
time
this
is,
problem,
time is up.
not
So-
bans, not ostracizations. This is not an issue about protecting women's rights. It's an issue about discrimination of a minority group. And if we only support the majority, what kind of a society are we?
All right.
Thank you.
Questions for this witness? Seeing none, thank you very much. Esther Belling, please. I think I've got that. Of Brattleboro, Vermont. Seeing, okay. Not here. Let's see. Simon D'Amica Price? Demaya Price. Thank you.
I had originally written good morning here, but I'll update it and say good afternoon. My name is Simon Maya Price. Thank you for allowing me to testify in favor of this bill. I graduated from Berklee College of Music last December with additional coursework in mathematics at Harvard University. I'm also a member of the LGB community. The bill at hand permits the classification of citizens by sex for purposes of bathroom, locker room, athletic, and prison access. This bill does not mandate such classification. If a citizen takes issue with a certain business's decision to segregate their bathrooms by sex, that citizen can participate in the free market that we so love here in New Hampshire by choosing to bring their business elsewhere or start their own business. This bill, contrary to the narrative pushed by the opposition, in fact maximizes freedom. It grants business owners and athletic organizations the ability to run things how they see fit. This bill does not diminish the rights of any group of people unless you would like to make the argument that men have a right to women's spaces. This bill and bills like it are supported by most Americans and most Democrats. I have a friend here with me today who is a butch lesbian and lifelong Democrat who supports this bill. I also have a friend who is of a more conservative persuasion, a bit too conservative for my liking perhaps. I consider myself to be fundamentally a classical liberal. Some of those who oppose this bill will claim that mandating that trans women, that is to say men, are allowed to enter women's spaces is suicide prevention. This is a lie. As a teen, I believed I was really a girl inside, and that either I was going to transition or I was going to die. This was a narrative pushed upon me by activists such as those you see here today. Now let me address the safety issue here by stating an uncomfortable fact. Female identifying men commit sexual assault at far higher rates than normal men. In 2017, a transgender identified man was convicted of sexually assaulting a 10-year-old girl in a bathroom. The transgender identified male boxer, Fallon Fox, said, "For the record," I quote, "For the record, I knocked 2 out. One woman's skull was fractured, the other not. And just so you know, I enjoyed it. See, I love smacking up turfs in the cage," end quote. 1 in 10,000 men are sex offenders in federal prison, whereas it is 1 in 1,000 for men who say they're women. When compared to a woman, a trans-identified man is about 60 times as likely to sexually assault a woman than a woman is. This doesn't surprise me at all. It takes a good helping of either naivete or misogyny to believe that womanhood is a costume. To those who compare this bill at hand to Jim Crow or segregation, I ask you to consider the following. If I came in wearing blackface and told you that I would kill myself if you didn't affirm my blackness, you would all call me racist and crazy. If I did the same with woman face, many would call me brave. Thank you very much.
Questions for this witness? Seeing none, thank you very much, sir.
Of course.
Is there anyone else here who wishes to testify, excuse me, to testify on Senate Bill 268? Seeing none, I'm going to close the hearing on Senate Bill 268. So I'm going to adjourn the meeting of the Senate of the House Judiciary Committee. That's it. I've put in the calendar for next Wednesday. We'll to exec the bill. Yeah, for all. You know what?